Is there any objection, or is it is somebody here disputing paternity?
No, not that I'm aware, but we were unable to get all signatures on an agreed order. So here we are. Yes, Your Honor, my client is here. She was, I saw her. Her name is Anna. And then one of the respondents, Your Honor, Mr. Robert Strong, is here. There's a second respondent, Janelle Amaro, and I do not see her.
Is that the mother
of the deceased? Yes.
I'm sorry. So who's the?
So my client, Your Honor,
a lot. Yes. I just, while I'm waiting, I want to make sure I have notice to the right people and that everybody who's supposed to have notice has notice. So yes. Your client is whom?
My client is Anna Robb. She is the mother of the child for whom we're seeking paternity. And Mr. Strong and Miss Amaro, who is not here, they are the next of kin parents of the deceased presumed father.
Got it. There's no other alleged father in the picture?
No, Your Honor, and we've done DNA testing.
Okay. All right. All right. That's what I really want. I just really want to know what type of hearing we were looking at. Thank you. That makes sense to me. Yeah, I'll probably do weed first and then y'all second, just to know. And then Lastras versus Lastras and Molinelli.
Good morning, Your Honor. Myron Kamiar on behalf of Kelly Lastras, who I believe.
Yes, I'm here as well.
Okay. We're here for a default, Your Honor. 10 minutes.
A default for what?
For a divorce.
For a divorce.
Yeah.
And what kind of notice have you given the other side?
We had to come back to get from Judge Delalado. We had to get substituted service, so we had to post. We had to post a citation and the petition to the last address. We also had to send it out via certified mail, which we complied with. The return of services on record, Your Honor.
Do you want a record?
We can. I mean, I can prove it up so that we can.
Right. Did you do an affidavit? Do you have an affidavit, or do you need to do a record?
No, we need to do a record, Your Honor.
Okay.
Yeah.
That's what I'm asking.
Okay.
Your client has not done a sworn affidavit.
No, Your Honor, she has not.
Okay. I might do these other two cases first, and you might be our last one. But if you'll just sit tight and go off screen.
Yes, Your Honor.
Thank you. All right. Let me get the weed parties back and make sure you're all here. Hold on one second. Give me a couple minutes.
Miss Sweet, are you there?
I am, yes.
Okay, when the judge comes back, can you just be on camera?
Yes.
Thank you.
All right, let's go ahead and go on the record. This is FM in the interest of the weed children. Let me take the attorney announcement and then the self-represented announcement.
I'm Jake Gilbert. I'm with my associate Logan Kilgore. We represent Justin Weed, who is the petitioner.
And then let me have the self-represented announcement.
Carrie Weed, pro se.
I will say, since I haven't seen this case in a while, and I've been happy with proceeding by Zoom, and I thought that made it easier for Miss Weed. Because she had been living in Montgomery County and we had tried to make it easier for her. But, and so the last time we were here, I think the court had found good cause to do it again by Zoom, just to make sure the access for her was allowed. But I understand that she has shown up this morning at the CFCF, and I want to make sure on the record that she is okay proceeding by Zoom, because this is why we did it. We did it for her to appear by Zoom. And so I want to make sure she's okay with proceeding by Zoom, or we can reset and we can set this in person.
I'm perfectly fine to proceed.
Okay, thank you. And then the other thing I will say about this case that's somewhat of a slaying thing to me is, despite all the court's notices about not recording and broadcasting. Somebody in this case has recorded and broadcasted it every time we've had a hearing. And it is not, I just want to make sure that none of the parties are doing that. And I wanted to ask the lawyers and Ms. Weed directly if any of you knew anything about that, because this case in particular has had some difficulty being republished and broadcast throughout the internet. So let me hear from Mr. Gilbreth and Ms. Kilgore first about whether or not they have any understanding of how that happened.
So I had seen that, I think our final trial was published on YouTube. I don't recall if it was both, because if there was we started in December and then there was essentially a default at the end. I know I saw the hearing from December published on YouTube. I don't have any awareness of how that came to be.
And if it's your client, Mr. Gilbreth, if you could just please, again, tell your client he is violating the orders of the court if he is the one who has let that happen.
My understanding, having discussions with him about it, and of course, anybody connected on my side, is that it's not been done on our side. And certainly wasn't done by my office.
All right. Thank you. Thank you for that. What about you, Miss Weed? Do you know anything about it?
If I may, just really quick, Your Honor, I do see a YouTube.
Right. We're on
coming this
YouTube
out.
because we're
I just wanna
required
make
to
sure.
be.
Right. It just
But-
said to me it was being recorded on my end, so I just want to make sure.
It's not
we're talking about
recorded,
it.
it's being broadcast because I think we believe that in order to comply with open courts, I could broadcast it in one of two places, either on YouTube or at the CFCF. And I'm choosing to broadcast it by YouTube, but we remove it, we delete it. That's consistent with our practices, but somebody in this case seems to have not honored that requirement from the court. And I was just, since I hadn't seen you and it had come to my attention, I was just seeing what anybody knew about it. Miss Weed? I think we lost her.
Something's changed. Can you hear me?
Yes,
Can you hear me?
I can.
Okay. I don't know what just happened, but something just updated quickly and then just came back to you, but it changed something. So I missed what you said.
I was just, before we got into the update for today, I was checking in on if anyone knew how this hearing had gotten republished on the internet, which was against our court rules. Mr. Gilbreth said he and his client were not responsible for it. And so I just turned to you and asked if you were responsible for it.
No, Your Honor, I'm not responsible for it. I wouldn't know anything about it.
All right, thank you. So let's update here. We wanted to, I'm going to go to Mr. Gilbreth first, for Mr. Gilbreth to give me an update on how everything's going with Mr. Weed and the kids, and then we'll turn back to Miss Weed.
Yes, ma'am. So my understanding, and of course, Mr. Weed can do the report himself as well, but my understanding is that the kids are doing really well. The daughter, Kendall, is doing great in school. And doing well socially and everything. Mr. Weed and the kids are in their own place right now. And so that's going well. Case, if you remember, he had issues prior with school attendance. That was one of the concerns that we brought at final trial. My understanding is he's knocking it out of the park with school. School attendance is great. Grades are great. Everything's going well. As far as the kids are concerned. My client, I think, would, as far as, the interaction with Miss Weed, there are, I don't believe, if I had to review the orders again, I don't think there's court-ordered FaceTime calls, but he has been doing FaceTime calls with the kids. I mean, Kendall's an older child, so that's obviously a little more difficult, but he's been doing FaceTime, but I don't think we've heard from Miss Weed in a few weeks, if not a month, asking for FaceTime calls. And then with regards to the possession and access, you had essentially said before Miss Weed has any possession and access that we have, this is on page 8 of your order. Essentially, that she meet with a licensed therapist of her own choosing. She notified Mr. Weed and myself of the therapist and the therapist contact information. And then that therapist was to assess Miss Weed's ability to take care of the children and her mental stability. I don't, if the court wants us to remind kind of what we went through the trial, but I assume you have notes and you recall the mental health concerns. But none of that has happened. Or if Miss Weed has met with a licensed therapist, she certainly hasn't notified us of that.
I'm going to come to
so-
you, Miss Weed. Miss Weed, you're going to get plenty of time. I really just wanted to get their position first, and then we're going to come to you. So just hold tight 1 second.
So essentially, that's where we're at for possession.
Let me ask you this, because your client, Mr. Gilbreth, had some significant legal issues going on. And one of the reasons there was some uncertainty in this case, there was a lot, because but was he had some legal issues that he was sorting out regarding issues in his life. How have those disrupted access at all with him? I mean, he's not been in jail at all. He's been able to handle those legal issues.
Correct. All that's been taken care of. And if you call, there was a divorce pending. Mr. Kirk actually represented the wife in that case. We settled that case. I think a divorce decree has already been entered on that. And so I don't think there's any legal issues that are affecting the children.
And is he under any current family violence protective orders against him?
Yes, as we agreed to resolve the divorce, we agreed to essentially enter a protective order for the protection of and I'm sorry, I'm blanking, Kyla Weed. And at
That's
the time
the
it came
ex-wife
before
that
you-
Mr. Kirker was representing.
Well, at the time you heard this wife pending divorce, and there was a 2-year protective order in place when you heard this, right? And so part of the to sell the divorce, they don't have kids together or anything. We just agreed to a lifetime protective order, right? There was a 2-year protective order in place when you heard it, and we just extended that because they don't have kids. There's certainly no reason not to do that.
Now, I couldn't remember if he had kids, but then with her or not. So there were no kids in that case.
Correct.
And does he have other kids other than the 2 at issue in this case?
Just the 2 at issue in this case.
All right. Thank you. All right. Miss Weed, Miss Carrie Weed, you have the floor now. I'm going to go ahead and swear you in because I think that makes the most sense. And that way you can tell us what's been going on in your life. In the testimony you're about to give, do you solemnly swear or affirm you'll tell the truth, the whole truth, and nothing but the truth?
I do, Judge.
All right. Thank you. So,
Your Honor.
you know, when we saw you last, I'm just going to be honest about this. Really, this case is closed in a lot of ways, but I had concerns about Mr. Weed. I had some concerns about you. I think we saw you and you were going through some health crises by your own story. That was when we saw you last. So I just want to catch up with you and see how you're doing and how you want any access with regarding to your children change. I don't know that you've met the legal requirements in the order, but let's figure that out and we'll see what you have to say about that. Go ahead.
Well, I've turned over all the documents that I can furnish in regards to my care and kind of my progress, and to the opposing counsel, and just kind of states kind of like my mental health and the stability that I am, like that the progress that I've made and the stability that I have currently. And that
Are you still
pretty
living?
much sums it up. I mean,
Are you, where are you living these days? Oh, we lost her again. We'll see if she can come back in. I'll take a quick break. Hopefully she can rejoin us. Well, she's not coming back. it's difficult to know if it's a connectivity issue or not. Oh, there. Maybe she is back.
Oh no, I was all right. Sorry about that.
All right. So the connectivity is hard because I don't know. We're having a difficult time. But my question to you was, where are you living?
Oh, with at 510, with my mother.
And so I do see that in the order that we entered back in March that we wanted to get a letter from a therapist that you had been having regular meetings with that therapist and that you were able to safely take care of the children. Do you believe you've provided that letter?
I believe that I provided something that is sufficient and adequate enough, because it's a little bit open-ended there at the end of the statement where it says, like, I can't remember exactly what the wording, like the verbiage is, but it just seems like there's nothing more I can really do.
Okay, I'm going to look at,
Sorry.
why don't you send that letter to the court? Why don't you email it to my email address? And I'll see if what that letter says. And then I'll see if we need to move to the next stage of the step up or not. Because it sounds like that's where we are. It's just really at stage 1 of the step up, Mr. Gilbreth.
Right. We actually uploaded as petitioners to what you provided my office. And my understanding is that she completed a 2-hour decision-making skills course and then went to inpatient. And that's what we uploaded as petitioners too. But as far as letter from therapist, regularly seeing a therapist, those types of things, that's not what she's done. But
There
everything she
is a
provided to
letter.
us is petitioners exhibit 2
Okay.
in the box.
Miss Weed, you were saying something?
Well, when she reconnects, I would have a suggestion on that.
I think she's here. I just think it goes in and out. So, but you report, Mr. Gilbert, that some Zoom or FaceTime calls are happening.
Yes, Mr. Weed would have to tell you the more of the specifics, but were, and then I think fell off within about the last month as far as contact from Miss Weed requesting them.
Okay, well,
order
why
is
don't we do it
specific.
this way? I think she's having difficulties with connectivity, Miss Weed. I think maybe we just need to probably, if you want an additional hearing, Miss Weed, if you think that they're not complying with the order, then you need to ask the court for a hearing, and we'll do it in person, I think. That might be the easiest way to go forward because I'm finding this a difficult way to go forward, and we can do it pretty quickly, but I think we're going to need to do it in person because I just can't get your connectivity, Miss Weed. I'm not able to hear from you fully.
Can you hear me?
Yes, but it keeps kind of going in and out. What are you wanting, Miss Weed? Is
Okay.
there something that you want?
I would like to be able to see my children on a video, at least, to do regular visits on a video. And then I would like to do like a visit in person, face to face. And there's no reason why I've showed you that I'm stable. I showed you that there was a letter from a therapist. It's exactly verbatim what you asked for. And I feel like this is like, you're
I need to look
bullying
at
me in
it.
court.
I need to look at it, and I'm not saying that we shouldn't move to some sort of some more regular FaceTime calls. I I have to look back at the order, but I think I'm gonna, well, now she's gone completely. So I think what I'm gonna need is I'm just gonna need whatever her communication is. We just need to do this probably in person. I'm not really for sure how else to do it. This just isn't working in any sort of helpful way. But I'm gonna leave it up to her to seek that. And so perhaps she will reach out to my staff, and then we will talk about getting something on schedule, and I will copy Ms. Kilgore and Mr. Gilbreth, and we'll have an in-person hearing. I recognize it's a little unusual because we are post-judgment, but I also, this case is just, there's just been a lot of things up in the air. I appreciate the fact that Mr. Weed, it sounds like the kids are doing well with him and that everything is going well. But I do think, just putting this out there, that video calls and maybe even a supervised visit could be the next part of the process. But I'm going to have to wait for Ms. Weed to reach out to my staff and work on getting something set in person, I think, because this just isn't working.
Yes, ma'am.
All right. Thank you.
Thank you, ma'am.
Everyone's excused.
Thank you, Your Honor.
Well, that didn't work very well. But I think the next one should, Ms. Murray, I think you're here with your client.
Yes, Your Honor.
I'm gonna take a couple minute break so Ms. Racanelli can get reset up too and get your case ready. I know you're planning on calling at least one witness, right?
I'm actually not, Your Honor. I really just have a few documents to show you.
Okay. Well, but should we take a record? Even though you just want to show me you think the record for the clerk is fine?
Yes, I do.
Okay. Well, then that's okay. Then I guess if you think that's okay, and you think is there an affidavit in one of those motions, or?
I want to make sure we're saying the same thing. I do think that a record of the proceeding today should be taken.
Okay, that's what I'm trying to do. That's all I'm trying to do is get a record of today's proceeding.
Yes.
So let Ms. Racanelli have a couple minutes to get that set up. Thank you. In the interest of DRS, a child, this is Judge Amy Clark Meacham. We are proceeding today on our remote procedures. Let me take the attorney announcements and any other pro se announcements for the record.
Good morning, Your Honor. Carly Gallagher Murray here for the petitioner, Anna Robb.
And then I think you have some respondents that you've notified of today's hearing, and one of them is here, and I'll let him make his announcement.
I'm Robert Strong. I'm father of the deceased.
Okay, thank you. All right, Ms. Gallagher, what are we here to do today? It's a little bit unique of a motion, so I'm going to let you lay it out for the court.
Okay, with your permission, Your Honor, I'd like to just kind of take you through the steps that we've taken from the beginning and then how we got here. And then if it's okay with you as we go, I'd like to submit appropriate evidence as we when we encounter that in the chronology, I'll just offer that for admission. In brief, Your Honor, what we're here to do today is to posthumously adjudicate paternity for the deceased father. So this case is an adjudication of paternity that we filed back in July of 2023. And at that time, this is the first case that I've done like this. And so at that time, my primary objective was to have the medical examiner's office test the decedent's biological remains so that we could determine that he was the biological father. And so at that time, the Travis County Medical Examiner's Office was listed as a respondent. So I began to do some research and kind of ask colleagues, look around, figure out, how we should appropriately proceed, and came to determine I've listed the wrong respondents. So in talking with the Medical Examiner's Office, they had the legal next of kin, the list of those persons and their contact information. And I had to submit a formal letter to them to ask them for that, which they provided. And so I sent a letter to them on October the 23rd of 2023, and then they provided me that list and contact information on November the 3rd of 2023. And that's at which point I came to know that Mr. Strong and Miss Amaro were the decedent's parents and his next of kin. And so I began reaching out to them and let them know what we were doing and asked them if they would be willing to sign a waiver of service. Mr. Strong, who's here today, signed his waiver of service, and that was filed on November the 9th of 2023. And Miss Amaro had a more difficult time getting that from her, which is fine. She's allowed to do that. So she was served on February the 9th of 2024. But then after that, she submitted her waiver of service, and that was filed with the court on February the 22nd of 2024. So we decided, or excuse me, we all began communicating then about whether we could enter an agreed order to do posthumous DNA testing. And we reached an agreed order. And let me back up. So prior to our reaching that agreement, I had set a hearing for that motion for March the 8th of 2024. We then all reached an agreement, and that was submitted to the court on February the 28th of 2024. So we passed our March 8th hearing. We were later told that the court was declining to sign the agreed DNA testing order. We weren't sure exactly why, so we reset the DNA testing hearing for May the 16th of 2024. And that was the point where the court confirmed the Mr. Strong and Miss Amaro as the next of kin and the proper respondents, and ordered the medical examiner to perform the DNA testing. So the DNA test was performed, and then the results were received and sent to all parties on June the 27th of 2024. And at that point, we began trying to reach an order to adjudicate paternity. And so I'd like to show you.
Sorry, I'm going to need to give you a note, I think, capability. But once again, they have changed my settings on Zoom, moved them all around. I think I just allowed you to do it, though.
Oh, okay. Okay.
You now have the ability to share screen.
Okay, thank you, Your Honor. So first, what I'd like to offer, and I probably
So
should
can I ask just basic, because you
Yes.
did this. So Mr. Strong, you're here. You are not opposing this motion, correct?
That is correct.
And then and your son was Robert Dillon Strong.
That's correct.
You're also Robert Strong, but that was his name as well.
Well, I'm Robert Paul Strong. He was Robert Dillon Strong. Yes, ma'am.
Thank you. And then Janelle Amaro, is that your ex-wife?
That's correct.
And she was the mother of Robert Dillon. Was the mother of Robert Dillon Strong.
Yes, ma'am.
And she answered in this case, it sounds like, Miss Gallagher Murray, but she's not opposing this. She's just not here today. Is that fair?
I really don't know, Your Honor.
But nothing in there's no paperwork from her in the record of the court that demonstrates that she is opposing today's motion.
There is nothing filed by her now.
And it's basically, I'm not even really for sure if it is a default, but as to her, I guess we're proceeding without her. She's answered, was given notice, is not here. So it's basically a post-answer default with regard to her.
With regard to her, yes, Your Honor. I still think that I'm required to show you.
No, I want you to show it to me. I just wanted
Okay.
to make sure her status.
Yes.
I wanted to understand her status. And
Yes.
then as to you, Mr. Strong, before we proceed to what Ms. Gallagher Murray, I think, needs to show the court and have the court enter as evidence, you're not opposing today's motion either, correct?
I am not.
All right, Ms. Gallagher Murray. I just had to get that table setting understood, and now proceed.
Thank you, Your Honor. So first, what I'd like to do, Your Honor, is show you what has been marked as Petitioner's Exhibit 1. Your Honor, this is the, what I've marked here, Petitioner's Exhibit 1. This is the death certificate of Mr. Robert Dillon Strong. And so I'd like to ask that this be admitted as Petitioner's 1.
Petitioner's 1 is admitted.
This is Thank where you, I've Your Honor.
Mm-hmm.
gotten to in my narrative, Your Honor. This is Petitioner's Exhibit 3, which is the affidavit for the business records for the DNA testing. The facility completed this, sent this to me, and I filed this with the court. I'd like to ask that this be admitted as Petitioner's 3.
3 is admitted.
Thank you, Your Honor. And this is the DNA test report that was performed by any lab test. Now it's been marked as Petitioner's Exhibit 4. I'd like to ask that this be admitted.
4 is admitted.
Thank you, Your Honor. If you'll take a look at this, Your Honor, a couple of important things to note are this combined paternity index number and the probability of paternity. Those are
So
two.
noted.
Thank
So
you, Your Honor.
noted, it's 99.99998%.
Yes. And then, Your Honor, this combined paternity index of 519,590 is also important. So, Your Honor, what I also want to show you, just so that you know that we're properly here today, because since Ms. Amaro is not here, I do want to show you that she was properly served. This is the notice of final hearing on the merits set here for today's. I've marked this as Petitioner's Exhibit 5. It's also part of the court's record. I'd like to ask that this be admitted.
5 is admitted.
Thank you, Your Honor. I want to just point out just a couple of things. This was served on Ms. Amaro at her email at Bearmaster on August the 24th. And you'll see also here that Mr. Strong was also served. This was served via the e-filing system, and then I also sent each party an email. Scrolling down below here, we'll see, Your Honor, that this confirms it's the automated certificate of service showing each party did receive that on 8/24/24.
I think I admitted already, but 5 is admitted.
Thank you, Your Honor. I just wanted to point that out. And then it was accepted by the court on 8/26 because 8/26 is a Monday. So this was sent to the parties on a Saturday. After that was sent to Ms. Amaro, and I have communicated with her quite a bit over the duration of this case at that email address that I just showed you, the Bearmaster email address, Ms. Amaro sent me notice. What I have marked here, Your Honor, as Petitioner's Exhibit 7. This is where Ms. Amaro let me know on October the 9th that she was changing her email address to sadness is that's approximately exactly a week before today's hearing. And so she said, I want to let you know that I'm changing this. And so I said, thank you for letting me know. I'll make sure that the Zoom link for our hearing comes to this address. I'd like to ask that Petitioner 7 be admitted.
7 is admitted.
Thank you, Your Honor. And then I'd like to show you as well, Your Honor, that what has been marked as Petitioner's Exhibit 8 is a subsequent email that I sent to Ms. Amaro at her new email address, where I forwarded her the link that this court sent to me. So this court sent to me the Zoom link on Monday, October the 14th. I forwarded the same link to her yesterday, which was October the 15th. I can't remember if I asked for this to be admitted. If I haven't, Your Honor, I'd like to ask that this be admitted.
8 is admitted. I do not believe that we have heard anything from her either about not being able to attend or not being able to access the Zoom link.
Thank you, Your Honor. So what I want to show you next, Your Honor, are the pertinent provisions in the Texas Family Code that allows you to adjudicate Mr. Strong's paternity. So
you can do that. Before you do that, can I ask why we're doing this? I do see your client here, and also I think the child maybe in the background as well. And how old is the child?
Is that to me?
Yeah. I'm just making sure that it's appropriate for her to be around. I think it's fine. It is. I'm trying to figure out though. I think what would help me, because I've never seen one of these before, and it's educational for me, is why you're doing this. That would be helpful. Is the purpose behind this action?
So, Your Honor, the child doesn't have a father listed on her birth certificate. If there were any Social Security benefits to which she might be entitled without a formal adjudication of paternity, she is not entitled to any of that. And just anecdotally, Your Honor, the child has an older sister who, same father, and that child does receive Social Security benefits because she is the acknowledged child of Mr. Strong. And then unfortunately, Mr. Strong did pass away before this child was born. The parties weren't married. And so that's the reason that we're doing it.
Right. That makes sense to me. I just wanted to know the why, which sort of explains why we're here and why we're doing all of this. Thank you. And also perhaps just to know and to clarify in law what is true in fact. But I wanted to understand why, because it's been a process. You've been doing this a while, and it hasn't been an easy way to get here to the end. So sure, you can go over the law with me. I looked at it a little bit already. So pretty briefly, I mean, there's no contest here really. So just put in what you need to put in, I think. You don't feel like you even need testimony from your client, I don't think. I've admitted everything in the record. So what does the order say really that you want me to sign?
So the order, Your Honor, is going to formally adjudicate him as the father. It also orders that her birth certificate can include his name and that her birth certificate can be otherwise modified to change her name if needed, although her last name is already correct. And then
what is her last name already?
It's Strong.
Oh, so she already has Strong as her last name.
She does, yes. But it allows for a father's name to be added.
But it doesn't need to be here because it's already her name.
Her name doesn't need to be changed, but and I didn't put that in.
Right. A name change is just something different. That's why I want to make sure. But it sounds like so the name doesn't need to change.
No, her name does not need to change.
Thank you. Got it.
So let me apologize, Your Honor. Somehow I've pulled up everything that I've ever submitted into.
You don't need to show me anything else. I think I have everything in Box. So you don't need to flash anything else to me. I can actually access it. If you put it in Box, I can see it.
Okay, thank you, Your Honor. And so if I could just for the sake of the record, just point to the provisions in the Family Code. So Texas Family Code 165-505 talks about genetic testing results. And basically what that rule says is that if we are talking about a compliant DNA test and at least 99% probability of paternity is established and not rebutted, then the man identified is the rebuttably presumptive father. And so what it says is that a man is rebuttably identified as the father if the genetic testing complies with this subchapter and the results disclose that he has 99% probability of paternity.
Excuse me, you're going to have to go back. You're reading way too fast.
I'm sorry, I do that. Okay.
So you said genetic testing complies with. Thank
you. Genetic testing complies with this subchapter and the results disclose that the man has at least a 99% probability of paternity and a combined paternity index of at least 100 to 1. It goes on to talk about alternative options for fathers and how one might rebut that, but that was not done, Your Honor. And then we look at section 166-31, and it talks about the rules of adjudication of paternity. Said the court shall apply the rules stated in this section to adjudicate the paternity of a child. When we go to subsection C, says unless the results of genetic testing are admitted to rebut other results of genetic testing, the man identified as the father of a child under section 165-05, which was the previous section that I mentioned, shall be adjudicated as being the father of the child. And then lastly, Your Honor, it talks about section 160-636, order adjudicating parentage. The court shall render an order adjudicating whether a man alleged or claiming to be the father is the parent of the child. And then it talks about the court would need to enter an order adjudicating parentage, and it must identify the name of the child and the date of birth, which is in the proposed order that I've given you. And then it says, if the order of the court is at variance with the child's birth certificate, the court shall order the vital statistics unit to issue an amended birth record, which is also what we've included. So what this court needs to see, Your Honor, is that the probability of paternity was at least 99%. And as I showed you in previously submitted exhibits, it did exceed 99%. And then I also needed to show you that it was a combined paternity index of at least 100 to 1. And if you'll recall, Your Honor, and I may have trouble pulling that back up again, but on that DNA test, Your Honor, that lower number, it was 519.
Yes.
And so I just wanted to point that out, that we are compliant with the family code. And so at this point, Your Honor, I would like to ask that you sign the order that we submitted as it's compliant with the Texas Family Code and the evidence submitted.
I'm going to make one change to it because the order you've submitted said, I think that Ms. Amaro appeared and she did not appear. So we need to change that because to officially recognize that she is not present for the hearing, even though she had received notice. And then I will also allow Mr. Strong, since he is the respondent party of record, he does not have to say anything, but I do want to give him the chance to say something if he wishes to say something for the record. You may proceed, sir.
Your Honor, I love them grandbabies. That's
That's
all I got
a
to say.
lovely, that's a lovely sentiment. Thank you for that. All right, Ms. Gallagher Murray. I will grant this motion and sign off on the order adjudicating parentage with that one change, as I just posited to you. Mr. Strong hasn't signed it. I don't need him to. I hear his assent. He is here. I know Ms. Amaro didn't sign it either. There's spaces for them to sign, is why I'm pointing that out on the record. But you've proven what you needed to prove, and thank you for complying with the steps that Judge De La Yata asked you to go forward and take. And at this time, I believe you have done everything you need to do for the court to enter in law what is already true in fact, and I will sign off on the order as presented with that one small change. And we can go off the record at this time.
Thank you, Your Honor.
All right. Thank you. Good luck to
you, Your
you.
Honor.
And good luck to those grandbabies. All
Thank
right.
you.
Thanks.
Thank
Y'all
you,
are
Your Honor.
excused.
Thank you.
In the public part of the hearing, that's fine.
Okay, thank you.
All right. All right. Thanks. So, Ms. Lastras, your attorney isn't on screen. Will you contact him and just make sure he's ready?
Yes, Your Honor, I just emailed him.
Okay.
Hopefully he's gonna pop back up here in just a moment.
Okay, I'm going to take a break and Miss Racanelli's getting set up anyway, and we'll wait for him to get back on screen.
Great,
Thanks.
thank you.
We're starting a little bit earlier than we anticipated. We thought 10:30, but we're getting to it earlier. So
Yes,
I'll
ma'am.
wait for him. All right, thanks.
Thank you.
All right. We're back on screen. And Mr. Kamahara, I need you to be on screen if that's possible. You're not on video right now.
Yes, Your Honor. Sorry, I was putting my jacket on.
That's all right.
I didn't want the court to have to see that.
Well, it's okay. It's Zoom. We've seen worse. All right. So we are starting back earlier than we anticipated, but that's great. If Miss Racanelli is ready, I think we're going to take a record, Miss Racanelli.
Yes, Judge, I'm ready. Thank you.
All right. So going on the record, this is FM, and let me take the attorney announcement and who you're representing for the record.
Thank you, Your Honor. Good morning. Myron Kamihara on behalf of Kelly Lastras, who's present.
And this is a default divorce, correct?
Yes, Your Honor. That's correct.
Are there any kids of this marriage?
No, Your Honor.
We have the first order of business, as we should say, is that Mr. Carlos Lastras Molinelli is not here. And let's go over what the record reflects with regard to his notice and all the requirements that our court has before you can proceed on a default judgment in a divorce case. Go ahead.
I understand, Your Honor. Your Honor, the respondent, the petitioner filed her petition in December of last year. We attempted to make service on, or effectuate service on Mr. Molinelli. He effectively evaded service, and then we had to file a motion for substituted service. And we initially filed the motion. We showed up to the hearing with Judge De La Lata. Unfortunately, our service was done untimely, according to the order for motion for other substituted service. Thus, Judge De La Lata amended the order and gave us more time. He signed it on July 11th, 2024. Amongst the requirements was leaving a copy of the citation together with petitioner's original petition for divorce and the order authorizing substituted service for Mr. Molinelli with anyone older than 16 years of age at 1220. Secondly, we had to, we would firmly affix a copy of the citation together with the petitioner's original petition for divorce and the order at the address. In addition to that, we had to mail a copy of the citation along with the original petition for divorce via certified mail to the address 1220 Orchard Park Circle. We completed and effectuated substituted service, and a first amended affidavit was filed with this court on August 2nd. service was executed on July 19th, 2024. And in the affidavit of service, the court will see that it is recorded that the citation and petition was affixed to the address, and we also sent certified mail the citation and petition.
Okay, I will take judicial notice of the file and that all the requisite deadlines have been met to proceed on a default judgment. So have you in this whole time, and this is for the lawyer first, but then I also want you to address it to your client when you ask her the questions. Have you ever heard from Mr. Lastros Molinelli in any of those efforts that you made?
We have. We corresponded back and forth together. He would not disclose his address. I made multiple attempts over Facebook, and my client did as well, Your Honor.
Okay. All right, well, let me swear in Ms. Lastros. I don't see that you've put any exhibits in the box, and so whatever you have is already part of the record, I think, because I don't have any way to admit any exhibits. But we'll take her testimony at this time. If you could please raise your right hand and be sworn in, Ms. Lastros. In the testimony you're about to give, do you solemnly swear or affirm you will tell the truth, the whole truth, and nothing but the truth?
Yes, I do, Your Honor.
All right, you may proceed, Mr. Kamahara.
Thank you, Your Honor. Please state your name for the record.
Kelly Lastros,
And Ms. Lastros, who are you married to?
Carlos Lastros Molinelli.
And we're here in a divorce filing initiated by you. Is that correct?
Yes,
Okay. And you filed the petition for divorce, the original petition for divorce, sometime in December of 2023. Is that correct?
yes,
And we attempted to traditionally serve Mr. Molinelli via process server. Is that correct?
yes. He goes by Lastros. Molinelli was the second last name.
My apologies. We attempted to serve Mr. Lastros by traditional means. Is that right?
Yes,
And we made multiple attempts, but been unsuccessful. Is that correct?
correct. However, your statement about Facebook was incorrect. He does not have a Facebook. He deleted it. We spoke with him via email for a little bit and then also Google chat. But he refused to give any address.
Just to clarify, we did attempt to look for him on Facebook, though.
Oh,
and it
yes,
was
we did.
deleted.
And he was
That's
not
what I
there.
meant.
Got
Okay.
it.
We also made multiple correspondences over email. Is that correct?
Yes,
And we asked Mr. Lastros to disclose his address so that we can traditionally serve him. Is that right?
yes,
After Mr. Lastros made it clear to us that he wasn't going to disclose his address, we decided to file a motion for other substituted service. Is that correct?
yes,
Okay. And in that original order granting motion for substituted service, we affixed the citation and petitioner's original petition for divorce at the address 1220.
that's my understanding. I don't live there anymore.
Okay. We also sent out the certified mail of the citation and petition for divorce to the same address. 1220.
Yes,
And then we went to a hearing on default. Is that right? On July 10th. Is that correct?
yes,
And in that hearing, Judge De La Lata identified that it wasn't timely done. And so we filed an amended motion, we drafted an amended order granting motion for other substituted service, giving us more time. Is that correct?
I believe so. Yes,
Okay. Now on July 17th, my process server went out and executed service in compliance with the first amended order for substituted service. Is that correct?
I believe so. Yes,
Okay. And thus we're here today asking the court to order a divorce in your case and to sign the decree that we are going to submit. Is that right?
yes, sir.
You already mentioned that you're presently married to Mr. Lastros, and prior to the filing of the original petition for divorce, you lived in Texas for at least 6 months, and you're a resident of Travis County for at least the preceding 90 days of filing the petition. Is that correct?
Yes, sir.
Okay. And that you and Mr. Lastros have ceased to live together since 2023. Is that right?
Correct.
And that your marriage to each other has become insupportable because of a discord or conflict of personalities that destroys the legitimate ends of the marriage relationship. Is that right?
Yes,
And there's no reasonable expectation of reconciliation. Is that right?
correct.
And as we told the court, there's no children of this marriage. Is that right?
Correct.
Again, we have
Is there any
drafted-
real property? Is there any real property?
No, Your Honor, just a vehicle. I can
Okay.
ask her that too. I was going to get
Yeah,
into that.
Thanks.
Okay.
Okay.
Ms. Lashes, what is the only community property in the marriage?
There are two vehicles, a blue Honda Civic and a gray Jeep Renegade.
Okay. And who's getting the Jeep?
I would be keeping the Jeep and he kept the Civic.
I understand. And we've distributed in the decree, is that correct?
Yes, he has, do you mean the debt or distributed what?
The
The
vehicles.
two vehicles? Yes.
Yeah. Okay.
Both were originally mine. I signed over the title of the Civic to him so that he had a vehicle. He took the Jeep for several months, but has since returned it to me. So those are both in the correct possession at this time.
Okay. Is there a loan on the Civic?
No, sir, that one is paid off. There is a
Okay.
loan on the Jeep, though.
Okay. And because you're keeping the Jeep, you'll keep the loan for the Jeep as well, right?
Correct.
There's a slew of credit card debts, medical bills, that have been properly distributed in the divorce decree. Is that correct?
Yes.
Okay. And you agree to that distribution scheme in the divorce decree, right?
Yes.
Your Honor, is there anything else you'd like me to ask Ms. Lashes? Thank you, Your Honor.
I think
Lastly,
I'm
Ms.
good. I don't have
Okay.
anything else.
All right. Lastly, Ms. Lashes, you're just asking the court for a divorce. Is that right?
That's correct.
That's the witness, Your Honor.
I think I saw one thing, and not for the witness, but for you, Mr. Kamahara. At one point, you would ask for attorney's fees, but I don't think attorney's fees are appropriate in a divorce case. And so, to the extent that's part of the judgment, I'm Xing that out. But everything else looks good. And having heard the evidence, the court is going to grant this default divorce and render a dissolution of the marriage. And I will sign off on the decree. Actually, would you send it to us again? You might have sent it to us in another way. But
I
you will
didn't.
send me.
I'll send it over though.
Okay, so send it to the 201.submission@traviscountytx.gov. And if you send it this morning, I'll get it processed this morning. But send it to me with your signature and Ms. Lashes' signature, and I will get it processed this morning.
Understood.
Your Honor.
Thank you, Your Honor.
Okay, thank you. And you all are excused and free to go.
Thank you.
We'll go off the record.
Did stipulate to all of our exhibits being admitted except for P7, which is one of mine. And I just wanted to let the court know. May I share my screen with the court, Judge?
So wait, are you offering exhibits and you want the court to admit exhibits? Because we need to, if you want to do that, we need to do it now. What you
So,
just
Judge, we
did doesn't admit
stipulated-
exhibits. So
Okay, we
are you offering
stipulated-
exhibits?
Yes, we both offered our exhibits, and we have stipulated that we both accept the exhibits that we have provided.
Okay,
Without
but you
laying
need to
it
do
out.
it with me. Y'all don't,
Okay.
y'all did it with each other, but that doesn't do anything. So do
Okay.
it with me.
Yes, Judge.
What exhibits are you asking the court to admit at this time?
At this time, P1.
You can do them in a group. P1
Okay.
through what,
P1,
except for
P2.
7. No,
Okay,
just
P3.
P1 through what?
P1 through P9, except for 7.
And I hear no, I think that is what Ms. Simone is also agreeing to. I'm hearing no objection. So P1 through 9, except for Exhibit 7, are admitted at this time. And I believe Ms. Simone also has some exhibits. Ms.
Yes.
Simone, what are your exhibits?
Correct, Your Honor. Mine are exhibits 1 to 4.
And you don't have any objections to those, right, Ms. Chapa?
No, Judge, we do not.
So, and then respondents 1 through 4 are hereby admitted. Now we will proceed and we'll just deal with 7 in the presentation of the evidence. Thank you.
Mr. Boyle, I have what's been pre-marked here as P1. I'm going to share my screen with the court. Is this your updated proposed disposition of issues?
Yes.
Okay. And monthly, would you get paid 26 times a year, correct?
Correct.
And what kind of expenses do you usually pay for related to the children? Let's talk about some of their activities that you pay for.
For soccer up till the start of this season, pay for their school lunches recently. Their braces for both of them, their dental work. Lorelai had a bridge done recently, paid for all that. Jameson's got his braces going now, so got that paid for too.
Okay. Let's talk about soccer first. Let's break it up. Who did you pay for soccer for?
For Jameson.
Okay. And how long has Jameson been playing soccer?
He played for 2 seasons.
Is Jameson pretty good at soccer?
Yes,
What's his position?
he's a goalie.
Okay. Why did you stop paying for soccer for Jameson?
Because the season ended in February, March, and he was already in Hutto half the time, so he was only going to half of his practices and half of his games. So it wasn't fair to his team. So I didn't put him back on another team to go half the time.
And before the children relocated to Hutto, where were they living?
In South Austin.
Okay. How far apart were you and Miss Estes living?
About 3 miles apart.
Okay. And how long had y'all lived 3 miles apart?
About 6 years, 6.5 years.
Do y'all have any family that lives in Austin?
Yes, my entire family does.
Okay. And does Miss Estes have family that lives in Austin?
Yes, her dad lives in Austin. Yes.
Okay. What area of Austin do they live in?
In South Austin.
Were the children close to both sides of the family?
Yes.
Okay. And had the kids been going to school in that area for those 6 years?
Yes.
Okay. What school was Jameson going to?
The most recent one before they moved,
Yes.
they were at the Idea School on Slaughter, which was between both of our houses.
Okay. And what school was Lorelai going to?
The same school.
Okay. How are the kids doing at Idea School?
They were doing pretty good. They were taking all honors classes. Every class there is all honors, and they were doing good, keeping good grades. I mean, they had a little bit of issues with middle school stuff. Other kids talking trash to them and stuff like that, but they were doing pretty good.
Who had issues with kids talking trash specifically, Jameson or Lorelai or both?
Lorelai, just middle school girl stuff.
Did these issues cause you concern?
Not really, no.
Okay. And did you ever talk to Lorelai about these issues with the other girls?
Yeah, and told her that if it's something that kept getting brought up, then she needed to talk to a teacher or principal. If it's something we needed to come in and sit down and talk about with the principal or whatever, we could get that part done, but it seemed to work itself out.
Okay. And were you going to keep Lorelai in the Idea School for high school?
No, because after they had moved, she said that she never told me this when they were going there, her or Jameson. They didn't like that school very much because it wasn't very diverse. So we would have looked at other options. They never told me that until after they were already gone.
Okay. And did you look, so based on what your kids' feedback is, do you take their input seriously?
Yes, of course.
Have you actually looked into other school options for the kids?
Yes, this summer I was looking at getting Lorelai. I got Lorelai on the list to get transfer for Bowie, and then Jameson got accepted to Bailey Middle School, but I wasn't able to complete the enrollment.
Okay. Had you spoken to mom about getting the kids enrolled into different schools in the same area, Bailey and Bowie?
No.
No. Okay. And why did you pick those schools specifically?
Because they're some of the best schools around.
Okay. And as well, Let's talk about schooling right now. Where does Lorelai go?
To Hutto, well, it's called ninth grade center. It's Hutto's ninth grade high school.
Okay. And if the judge today told you, Mr. Boyle, you get to take the kids out of school, you get to designate their primary residence, are you planning to take those children out of school in the middle of a semester?
No, absolutely not.
What is your plan if you are able to designate, if the judge did decide that you can designate the primary residence and the kids go to school based off of that?
To get them into the transfer and into Bowie and into Bailey, get that done back into AISD.
When?
Start of next semester.
Okay. And do you think it's in the best interest of children to transfer them out in the middle of a semester?
Not necessarily.
Okay. And right now, where is Jameson going?
He's going to Hutto Middle School.
Okay. And how is he doing in school?
Good. Keeping good grades, taking all honors classes.
Okay. And what kind of possession schedule are you currently exercising?
50-50, week on, week off.
So you still wake up, well, tell the court a little bit about their routine when they're in your possession. What time do you wake them up at? What time do you get them to school at?
Get them up about 6:15 so they can get ready, and we leave at 7. And get Jameson to school first. Drop him off a little before 8, and then get Lorelai over to school. It's not too far away. Get her there usually by 8:15.
Okay. And what about when you go and pick up the kids from school? How does that work?
I have to leave work and then go pick them up when they get out. I leave work at like 3:15 and go pick up Jameson when he gets out at 3:40. And then from there we go over to Lorelai's school and wait for her to get out at 4:30.
And when y'all get home, what time do you usually get home with the kids after school?
About 5:30, 5:15, 5:30, somewhere in there.
And what is their routine like after school?
We look through their homework, get their homework started, and then as I'm making dinner, and then they get a shower, and they usually get about 45 minutes to an hour of free time, and then it's straight to bed.
What do the kids like to do in their free time?
Mostly just play games with their friends on the computer.
Okay. Do you monitor what they're doing on the computer during their free time?
Some I have. I mean, I'm not sitting over their shoulder or anything, but I do have parental control set up on Jameson's computer and on Lorelai's computer.
Okay. And what do you like to do with your kids during your possession time?
We go to a lot of the Austin FC soccer games. We find anything else to do, stuff around the house. Baking. Lorelai really likes baking, so been doing that a lot lately.
Okay. Just for the court, who is this to the left right here?
That's Lorelai.
And who's this to the right?
Jameson.
Okay. And are these just some pictures that we have of the kids?
Yep, Lorelai finished that puzzle.
Does Lorelai like puzzles?
Yes.
Does she like to go to the games?
She does. I think she likes the snacks more than the game itself, but they have a good time.
Okay. What kinds of issues would you say exist with the children now living in Hutto? Well, let me ask a different question. Why did you file this modification, Mr. Boyle?
Because the kids expressed to me after they had moved to Hutto that they didn't want to move to Hutto and they wanted to live with me.
Okay. And as far as possession time goes, why not continue with the 50-50 schedule that y'all are doing right now?
Just the amount of time in the car for the kids back and forth. It just doesn't make sense, and all the extra gas money and toll bills and stuff like that just doesn't make sense to have them travel back and forth so far.
Okay. And do you and Miss Estes have a problem co-parenting, would you say?
No,
Do y'all have a relatively good relationship?
yeah, for the most part, yes.
And would you say that well, okay, let's talk about decision making. You're not asking to change decision making, correct?
Decision making?
Yes, like you're fine with everything in the previous order staying. Y'all are just joint managing conservators, correct?
Yes.
And as far as what are your main concerns whenever the kids what are your main concerns with the situation and the possession access schedule as it exists today?
Just that the kids said just said they don't want to live with her anymore. That they want to live with me all the time.
So let's talk about some of their life. You mentioned that they have braces, correct?
Yes.
Do they have an orthodontist or a dentist?
Both.
Both. Okay.
Yes.
Where are the orthodontist and the dentist?
They're both located at Petite Dental and Orthodontics in South Austin.
Okay. Do they have a primary care physician?
Yes.
Where is their primary care physician located?
Is Southwest Family Medical and Dr. Cox in South Austin as well.
Okay. Do either of them have therapists?
Yes, they both do.
Okay. And where is their therapist located?
In Buda, actually.
In Buda.
Yes.
And how? Well, where's Buda at? For me.
It's south of Austin in Hayes County.
Okay. And who usually takes them to their dentist appointments?
I have been.
You have been for how long?
For the past year at least.
Okay. And you mentioned earlier in your testimony, you said that you had been paying for Lorelei and Jameson's braces, correct?
Yes, that's correct.
Okay. And the current orders right now, how are y'all supposed to split the cost of braces and the expander, I think you said, for Lorelei?
Yeah, she had the expander, she had braces, she had a bridge done as well. That's all supposed to be split 50-50.
Okay. And you heard earlier that the other side is going to be asking for retroactive child support going back to December, correct?
Yes.
How much have you spent? Well, has Miss Estes reimbursed you for braces, expander, the bridge, all of those?
Objection, Your Honor, to relevance. This is still reimbursement is not really part of a modification.
Right. I'm not understanding. What do you want to do going forward? That's the question, really. Ms. Chapa, I don't think we can go backwards.
Right, Judge, but if they're asking for a retroactive and, you know, there's this
They're asking for retroactive child support. I don't know that they can get retroactive reimbursement that wasn't in a previous order. I don't think that anybody can get that.
Correct, Judge. I'm asking the line of questioning more so to say, if you're asking for reimbursement, perhaps the court with your discretion can say, well, since he's paid all of these bills and hasn't been reimbursed for them in lieu of an enforcement, you know.
Yeah. I mean, let me just say this too. I'm worried about y'all's 3-hour announcement. I think you're way under announced because you don't understand how difficult it is to have a certificate with or have a conference with kids. It usually takes about an hour. And so you're very limited on your time. So part of it is just a timeliness thing that we really have to be done with this by 3 because I got to then set up the kids meeting with me and have some sort of Zoom conference, I guess is what you want. And so you just don't have a whole lot of time.
We were fine with the kids going in person. We just wanted your direction because obviously we don't want to take the children out of school. But it's
right. I'm happy to do it by Zoom. I just, y'all announced this for 3 hours and I think you're way under announced.
Okay.
Given what you're trying to do here. So I just want you to be responsible about time. I'm going to be done at 4.
Okay.
Maybe even before 4. So we're going to be done at 4.
Okay, Judge. Thank you.
Thank you.
Okay. Mr. Boyle, let's go ahead and get into some of those, let's go past the expenses. What concerns do you have related to, well, how have y'all really split your time between the children? Let's talk about that. Is it a true 50-50 or what have you and Miss Estes done traditionally?
Yeah, I mean, for the most part, it's 50-50. Every once in a while, something will come up where, we try to get extra time with them to take them for whatever it is, go hang out with the cousins or to, extended time at the beach or something like that. But pretty much just 50-50, yes.
Okay. And whenever one of y'all needs help with the children, like if you need help with the children, is your first person that you go to mom?
It depends on the situation. Half the time, yes. Half the time, see who, if it's just something for a day, I could see, my parents are right down here in South Austin. So just give them a shout, see if they can come, take the kids for the night.
Okay. And whenever, in your experience, whenever Miss Estes has had issues, does she usually, or needs accommodations, does she usually reach out to you?
Yes.
Okay. Can you give some examples of when that has happened recently?
It hasn't happened since she moved, but I mean, before I don't know exact time when it happened last, but she had to work some night and then like, hey, just get the kids a day early because I got to work. So we'd pick them up a day early.
Okay. Who lives in your house right now?
My wife, Catherine, Lorelai Jameson half the time, and then my stepson, Jordan.
Okay. And I'm going to share my screen.
Your Honor, sorry to just interject. I just want to clarify with regards to the time. If it's petitioner's motion to confer with the children, that's not actually going to be eating into the time that I will have to present my case as well. Because they've got really
I think probably what you're looking at is we'll just get done about 2 hours worth today, and then I'll have to reset y'all for later. I don't know. It's a wildly inaccurate time announcement. I can already tell. When you try to do a final in 3 hours, it just doesn't work. And so when you try to do a final in 3 hours, it's really not possible. Rather than making you reset, Ms. Simone, because I think that would prejudice you, I'll just listen to this and then we'll reset you for a later date because I just don't see how y'all are going to get this done. I'm going to be absolutely honest with you. We've been going an hour, and even if you only call Mr. Boyle and Ms. Estes and have conferences, there's no way. So we'll just figure it out. We're not going to finish today. We have to schedule something with the kids anyway. And so we'll talk about that. Let's just get through this. Let's get through what we can get through, I guess. And then we'll work on a reset.
I do apologize, Judge Meacham. I thought conferences with kids, some judge told me it was 20 minutes and done. So I was anticipating an hour and 10 minutes.
Well, even if you thought that, even if I just think even if you thought you could get this done with 2.5 hours, I think that was not realistic, probably.
Okay. Understood.
That's what I'm thinking, because you're probably about halfway through. She has to go. It's just not a realistic announcement.
Okay. I'm so sorry, Judge.
That's all right. Keep going.
Okay. I'm going to share my screen with the courts. Okay. Mr. Boyle, is this the room? Is this your house?
Yes, that's Jameson's room.
Okay. And that's
Lorelai's room.
Okay. How long have you lived in this home?
Just over 7 years now.
Okay. And did you design the rooms or did the children?
They had the input in there. They helped with it, but Lorelai picked her furniture. We just painted that wall as a surprise for her one day. We're still waiting on Jameson to pick a color.
Yes. And Jameson's room is looks like it's soccer themed, correct?
Yes.
Okay. Did you and let's go to the extracurriculars. Did you and Miss Estes ever try and work out a compromise for his extracurriculars?
There was option with his coach down here in South Austin so that he could go practice with a team in Cedar Park, I think, or Round Rock, Georgetown, somewhere in that area.
Okay.
But I don't know I don't think she ever took him, maybe one time.
Okay. And right now, and to your knowledge, is he on his school soccer team?
No.
Is he doing any kind of club soccer or anything like that?
No.
Why did you put him in soccer in the first place? What was the purpose of it?
Just because he enjoyed it. He was on a rec team for a while. He was better than a lot of the kids, so we decided to move him up into a club level.
Okay. Do you have plans to, well, do you and Jameson have plans together to continue his involvement in soccer?
Yeah, I'd like to get him back in soccer for sure.
Okay. And as far as your involvement with the children, would you say that you're pretty involved with their lives?
Yes.
And how involved are you?
Help them with their homework, take them to their appointments, take them to school, all that stuff, taking Jameson to all his games and practices.
Were you involved in their schooling when they were at the idea school?
Yeah, I mean, I would get messages from some of the teachers about how they were doing. Yeah.
Did you go to back to school night, parent teacher conferences, anything like that?
At IDEA, yes. We went to the open house and meet the teacher. And they had a 504 meeting for Jameson that I went to.
Okay. And let's talk about the 504 meetings. What is there anything specific about Jameson that was addressed in 504 meetings?
That he could, have extra accommodations for tests and things like that. And he could get timeouts if he was getting overwhelmed in class.
And does he have, what's the diagnosis? Does he have a diagnosis?
ADHD.
Okay. And does he do, to your knowledge, is the same 504 plan put in place at his new school in Hutto?
Yes.
Okay. And what changes have you noticed since the kids have moved over to Hutto with their personal behavior?
Jameson, nothing really. Just he's good at making new friends. Lorelai, I mean, she's been a little down. I don't know. She's been more quiet than normal.
And whenever you and mom, what schedule do y'all do the pickup and drop offs? Like, how do y'all do that?
The Sundays at 6 o'clock, they get dropped off on the let's see, we switched it. So the week that, like this past week, they're with her currently. So I took them on Monday this week because they were out of school. So took them Monday at 6 o'clock and dropped them off.
Okay. And are they excited to go back to their mom usually?
No, they seem indifferent. Jameson usually doesn't want to get out of the truck.
And what do you mean by Jameson doesn't want to get out of the truck? Like he just says no, or can you be a little bit more specific?
He says, I just put
Sorry, without saying what he says, can you let me know about his physical demeanor, Mr. Boyle?
He just gives me a hug for a long time and, waits until right at 6 o'clock to get out.
Have there been any real changes with the kids now that they live further away?
What do you mean? What type of changes?
Well, like personality, behavior. Did they have friends in South Austin?
Yes.
How many?
A bunch. Jameson, I mean, he hung out with a lot of kids from his soccer team, and Lorelai had friends at school, friends from her old school, and even friends from elementary school that she was still hanging out with.
Do you know whether or not any of these friends of Lorelai's would be going to Bowie?
Some of the kids from her elementary school, yes.
Okay. And do you know whether or not she talks to any of those kids that you're mentioning?
Not sure. One of them moved. I'm not sure if she's still talking to all of them or not.
Okay. And Jameson, will any of his soccer buddies, will any of his friends from IDEA, do any of them go to Bailey?
Some of the kids on his soccer team go to school there, yes.
Okay. And so if they were to be moved to a different school, would they have friends to your knowledge?
Yes.
Do they have friends at their new school?
They talk about kids there, yes.
Do you take it lightly that this would be requiring you to take your kids out of a school that they're at and move them to a new school?
No, yeah, no. I mean, I know how it is to switch schools. It's not easy.
Do you think that it's in their best interest that what are you asking the court for? Are you what kind of possession and access schedule are you asking that the judge give mom?
Just the expanded standard possession.
Okay. And do you believe that that's in the best interest of Jameson and Lorelai?
Yes.
Okay. Are you asking that mom pay you child support?
No.
Do you have the financial means to support the children without Miss Estes' child support?
Yes.
Okay. And you're still asking that medical expenses be split up 50-50, correct?
Yes.
And who is covering them under health insurance, vision, dental?
That's me.
Okay. And are you planning to keep them covered?
Yes, for sure.
Okay. Who are you asking be allowed to designate the primary residence of the children?
Me.
And are you wanting to enroll them into a school based off of this primary residence that they're going to be spending the majority of the time at?
Yes.
Okay. Logistically, does it make sense that wherever the kids are at most of the time, they would go to school in that area?
Yes.
Okay. And you're asking everything else stay the same, correct? You're joint managing conservatorship.
Yeah.
You're fine with keeping them in Travis County, correct?
Yes. Yeah.
Do you have any plans to move them any further than that?
No.
How long have you lived in the house that you're living in right now?
Just over 7 years.
Do you own it or do you rent?
Own.
Okay. And do you think that the orders that we've requested are in the best interest of Lorelai and Jameson?
Yes.
Most importantly, are you asking the judge to confer with the children and take their wishes into account when making a determination on this final?
Yes.
Do you believe that your children are at an age where they can speak for themselves?
Yes, I do.
Okay. I pass the witness, Judge.
Miss Simone.
Thank you, Anna. Mr. Boyle, you are aware that when you divorced, you agreed that either yourself or Mr. Estes could live in Travis and the contiguous counties to Travis County, correct?
Yes.
So either of you actually have the right currently to move to Williamson, Bastrop, Hayes, and all of the contiguous counties.
Okay. Yes.
So Mr. Estes hasn't actually done anything wrong under the decree.
Was that a question?
So yes or no, she hasn't actually done anything that she's not permitted to do under the decree.
No.
Okay. And you're also aware that in your decree, with regards to school enrollment, if you had moved from your address, Miss Estes had the right to enroll the children based on her address, correct?
Yes.
So again, she hasn't done anything wrong as per your decree.
Yeah, no.
And so with the move to Hutto, it's probably correct to say that you weren't happy that she moved to Williamson County, correct?
Correct.
And she did make attempts to communicate with you about the move, didn't she?
She sent an email.
Okay. And I'm just going to share my screen, Your Honor. That here. Is this the email that exchanged from Miss Estes to yourself?
Yep.
And this exhibit has been admitted. So she notified you on November 5 that she would be moving to Hutto, correct?
Yes.
And that was prior to you filing the modification petition?
Yes.
And she went into great detail about her reasoning for why she was wanting to move to Hutto, correct?
Yes.
And part of that reasoning was because she'd been told that you were moving to Corpus Christi.
That's what she said. Yep.
And she had offered or had suggested particular possession schedules and ways that you could work around the move, considering that she would be a little bit further away, correct?
Yes.
And also about medical appointments. She went into detail about medical appointments, who would still continue to take them, things like that.
Yep.
And she also spoke about therapy, which she named as mediation, about seeing the therapist and having a session together, correct?
Yes.
And also she mentioned about soccer for Jamison because that was important to him.
Yes.
And you never replied to her, did you?
No.
And you didn't discuss any of this with her?
Nope.
Okay. And isn't it correct that approximately December 14, the children's therapist also emailed you to offer you an appointment for yourself, your wife, and the children so you could discuss the move?
Yes.
Yeah. And did you take her up on the offer to have an appointment with the family?
Yes.
And when did you have that appointment?
I don't remember the exact date, sometime in December.
Yeah. And Ms. Estes also made another attempt to communicate with you about different alternatives for possession schedules towards the end of December, correct?
Yes.
And you didn't reply to her again, did you?
Nope.
So you've refused to communicate with her about the move, potential possession schedules, and what you could come to an agreement on regarding the children and the move.
Yeah. Yep.
Okay. And do you think it's in the best interest of the children that you stop communicating with the co-parent, with your co-parent, about the children?
I didn't stop communicating with her, just about the custody stuff.
Okay. And with regards to Jamison, you didn't attend his 504 meeting with the school in Hutto this year, did you?
No.
But you were invited to that meeting, correct?
I was given, a 1-day notice, and I had meetings at work that I couldn't get out of.
Yeah, but you didn't reply to the email from the school, correct?
No, but I did call that lady, and she never returned my phone call.
Okay. And so with regards to the kids and their school grades, you testified that currently at Hutto, they're actually doing perfectly fine with grades. They're doing well, correct?
Yes.
And so their grades are about the same as when they're in Travis County?
Yeah, I'd say so. Yes.
But you're still wanting them to move schools again?
Yes.
Okay. So you want them to, you don't like what Miss Estes has done with the disruption of the children's school, but you want to now do the same thing?
Yes.
Yeah. And how is that in the best interest of the children?
Because I'm more stable, and I've been in my house for 7.5 years, and I'm not moving. Once they're here, they're going to stay.
But you can't be for sure that you'll never move. I think that's sort of a bit of speculation. No one can guarantee that they'll never move. You can't guarantee to the court that you'll never move.
I mean, I guess never's not. I mean, yeah, I have no plans on moving.
Okay. So when the children started attending Hutto, did you attend any of their course selection fairs, their academic and college fair, things like that the kids had for their schools? Oh, did we?
I think we lost him. I think he just got disconnected. So we'll wait a second.
Okay. Let me call him really quickly, Judge.
Yep, we'll wait. I'll give it 5 minutes. I'm gonna take a quick break. Thanks.
Judge is just taking a quick 5-minute break. Joe, you're fine.
Oh,
She
okay.
figured that you got disconnected. So
I did.
yes, you and Miss Simon will pick up. Is it Simon or Simone, Vanessa?
It's Simone.
Simone, okay, please correct.
It's confusing because it's kind of like a first name and then people get confused, but it's fine.
Okay, Miss Simone, she'll go ahead and take up questioning again when the judge gets back, so just hang tight.
All right, I'm back. We can pick back up with where we were. We can go back on the record. Thank you.
Thank you, Judge. Mr. Boyle, I was just asking you with regards to the different activities, course, fairs, and things that the kids had with Hutto. Did you attend any of those?
You mean just that 504? No, that's the only thing I missed.
No, there was an advanced academics and college fair for Lorelei. There was the fish camp. Did you attend any of those types of activities, events?
No, I did not.
And with regards, so if you didn't attend the advanced academics and college fair, are you aware for the high school that you want to send her to, what options she has with regards to college and classes and things?
I haven't looked into that yet. I mean, she's in 9th grade, so I haven't really looked into that yet.
And you testified that you had parental controls on the kids' computers, correct?
Yes.
And what about on their phones? Do you have any controls?
Not on Lorelei's phone, no.
And she's 13, am I correct?
Yes.
And does she have social media accounts?
14. She's 14, sorry.
And does she have social media accounts?
She has Instagram.
And so you don't monitor any of her online usage on her phone for that?
No.
Yeah. And what is your current work schedule? What kind of hours do you work?
Typically work 7 to 5.
And that's Monday to Friday?
Yes.
Okay. And at the time of your divorce, neither parent was paying ordered to pay child support, correct?
Correct.
So were your and Miss Esther's income roughly about the same then at that time?
I think so. I think she maybe was making a little more.
Yeah. And do you recall approximately what was your income at the time of divorce?
Oh, I don't know, 48, 50,000, somewhere in there.
And so you now earn 100,000 plus, correct?
Correct.
So there's been a significant increase into your income.
Correct.
Yeah. And with regards to, you mentioned the braces that the kids have to get. You didn't confer with Miss Estes about getting the dental treatment, did you?
Yeah, I let her know that Jameson had to get braces.
Yeah. Did you let her know in advance what kind of cost it would be so she could have some input on whether she could afford that?
I mean, no, it's just whatever the braces cost, that's what it is.
Okay, so you didn't factor in her financial situation and the fact that you earn significantly more and neither pay child support with regards to that?
No.
Okay, that's all I have, Your Honor. I'll pass the witness.
Just a few questions for Mr. Boyle, Judge. You testified just a moment ago that you didn't attend a few events for Lorelei, correct?
Yes, correct.
Why haven't you been able to attend all of these these educational events for Lorelei at her school?
Because they're, start at 6 o'clock and I can't get up there in time after getting off of work.
Do you think it's in the best interest of the children that both parents are able to attend the educational, student fairs and stuff like that? Especially, well, do you think it's in the best interest of your children that y'all both be able to attend?
Yes.
Okay. And has the move made it almost impossible for you to attend these events?
Yes.
And would you like to be present for your children when we're looking at college options, courses, etc.?
Yes, I would.
Okay. And as far as, well, actually, no further questions, Judge.
Mr. Boyle, so last year your kids were in IDEA charter school, is that right?
Yes, correct.
And what grades were they in last year?
They were in 6th and 8th grade.
And the older is Lorelei. Does IDEA charter school go beyond 8th grade?
Yes, it goes all the way to all the way through 12th grade.
But you have no desire to put them back in IDEA?
Well, not after they expressed that they didn't like it that much because of the not being very diverse.
So they were always asking you, and probably Miss Estes as well, maybe to change their school at the end of last year? Or was this something that's newly developed?
That was something that they told me after they had started at Hutto.
And you live in the Bowie footprint, is that right?
I do not.
Okay, then what footprint do you live in?
It would be Aikens High School.
And so have you explored how hard it is to get an intra-district transfer from Aikens to Bowie?
Yes.
But you haven't, right now, you don't know if you can do that in the middle of the year or not.
Not 100%. No.
And then what middle school is your house zoned for?
Perez Middle School, I believe.
And again, you'd be seeking a intra-district transfer for that as well. Is that right?
Yes, I already got Jameson approved for, initially it was small middle school, and then he did get approved for Bailey over the summer, but I wasn't able to get the enrollment done because the hearing wasn't complete.
And my memory is telling me that Bowie might be closed for intra-district transfers. Do you know if that's true or not?
She was on the list.
You don't know though. You aren't sure. She was on some sort of list, you think?
No, she was on the transfer list. That was the only school I put her on the transfer list for. It didn't say it was closed for transfers. It was just, I guess, as needed maybe, or as.
It's just a very full school.
Sure.
And I know it's one of those schools that sometimes goes in and out for transfers, and it doesn't sound like you know for sure. So I'm going to have to talk to them and ask them what they want to do. But what they want to do and what is possible for them to do may not be the same things. So your intention is what if you were to get them back in your house as primary and also be able to make the education decisions? What is it that you would want to do with both of these children, and how soon would you want to do it?
I'd want to get them, Lorelai into Bowie and Jameson to Bailey, because Bailey transfers straight to Bowie, and just to keep them with some people that they know and get them in the best school in Austin.
But I don't think you testified they knew that many people in either one of those schools. So do they know people there, or do they not know people there?
They do. Lorelai does, and Jameson, actually 2 of his cousins go to Bailey, and some of his friends from soccer.
But the intention is not to send them back to IDEA.
No.
And he's enrolled in soccer with which soccer club?
Lone Star.
And is he on Lone Star North practices or Lone Star South practices?
South.
But he's not currently enrolled.
Correct.
But
Correct.
You understand that there's a lot of Round Rock locations for Lone Star practices.
Yes.
And so if he wanted to be involved in Lone Star still, he could just be on the Lone Star North.
Yeah, I guess so, yes.
All right. But he has a specific team he'd like to be back with? Have you talked to Lone Star at all about whether that would be possible or not?
Yes, he's got a new coach, and I've been in contact with him and letting him know that try to get him back on the team as soon as, as soon as we get everything figured out here.
Do you understand that the amount of days that are different between week on, week off and expanded standard is actually pretty slim? It's only like 2 or 3 days a month when you consider it all and you consider how the summers work. And so what is your thinking with regard to that? Moving from a week on, week off to a parent who's primary and another parent who has access to expanded standard, what do you see as the big difference that would make it a better situation for your 2 kids?
Well, I mean, that's just what they expressed to me. They don't want to live in Hutto. They don't want to go to a different school. Obviously that didn't happen. That they want to live with me, and that's why I started all this stuff, just because that's what they have asked me. So.
But you understand that expanded standard means 45 days for mom in the summer and long kind of weeks during the school year, even spring break and, long weekends every time they're available. You understand there'd still be significant visitation for mom in those circumstances.
Yeah, I understand.
And they don't really want to go back to the school that they were in. This is about going to a different school entirely.
Yes, I guess so. Yeah.
But you think that's what they're going to tell me, is that they want to be in different schools than the Hutto schools.
Yeah, I would think so.
All right. I'm just trying to under what I'm walking into, because people ask me to talk to kids a lot, and I want to understand what the realistic picture is, because sometimes kids want things and they don't understand things like intra-district transfers, and they don't understand things that often are harder than what they believe them to be. So I appreciate that. Based on the questions that I just asked, do either of the lawyers have any other follow-up questions? Since now it feels like we're really about schools. That's what we're really talking about for schools. That's what I heard, Miss Choppa, Miss Simone. I'm hearing, let's do all this so the kids can go to the schools they want to go to. Which, by the way, is a very important thing for this age of kids. I'm not saying it's not. I just kind of want to understand why I'm interviewing them and what you think they're going to tell me. And now I'm talking to the lawyers.
I guess without going too into detail, Judge, my client, the kids have indicated they wanted to spend more time with him at his residence versus mom. And I explained to my client, realistically, the majority of the time, unless there's something horribly, horribly wrong here, which we're not alleging, usually judges are going to err on an expanded standard possession order. It's rare that we go down to just Friday to Sunday and stuff. So I set expectations for my client and let him know, this is what most judges are going to do unless there's, some kind of horrific issue here. And realistically, this is not a situation where we have two bad parents or even one bad parent. These kids are at an age where they have a preference over time spent. They didn't tell us I want to spend, 60%, or they didn't tell him I want to spend 70% of the time.
What I don't know that people are understanding, and maybe these kids, this age child, which by the way is the most typical modification I see. I've done these. I've been on the bench now 14 years, and I can promise you, perhaps the most typical modification I have is 12 to 15-year-old children who are wanting to have more autonomy and more say in what they do, oftentimes, for whatever reason, rebelling against their mothers, sometimes their fathers, but a lot of times their mothers, and starting to have fights with them on a consistent basis. And again, I'm not saying that I'm not going to listen to them. I'm not going to listen to them and what they want. The law says we're supposed to. I do think there is an important part of empowering kids at this age too, and making sure they're committed to their choices, because they're going to have to start making choices for themselves. And this is much less about parents now and much more about peer groups and schools, because that's the life that they are living. They're aging. And I think both of you are probably trying to do the right thing here for your kids, but I'm just trying to figure out what the fight is. And the fight there's not a huge amount of days difference between expanded standard and 50-50. I think somebody counted it up once, and expanded standard is about 54-46 and 50-50 is 50-50. So those are really the time differences. It's not a big difference, but yet both of you, mom's not arguing to not modify, mom's arguing let's modify too. And so there's just not a lot of understanding, I think, that difference is not that strong in number of days. And now I understand we live far from each other, but quite honestly, you still have to go on Thursdays and Fridays and Mondays and Tuesdays, and there's still a lot of travel involved in the 50-50 schedule. I mean, in the expanded standard schedule. I think it lowers it some, but it doesn't take it away. It really just takes it from 5 days a week every other week to 2 or 3 days a week every week. So it's not really, it's not the sort of thing where it changes things a lot. I just want to make sure the parents understand what they're fighting about here, when both of them are arguing kind of, let's make all these big changes, but the big change is not that big of a change. Now, it's a change in how perception works. It's a change in how changing schools is a big change. So if I'm going to talk to them about what school they want to go to and what's a realistic possibility, I just need to know what is actually a realistic possibility. And so it sounds like that's where we are. I just want to make that clear in the middle of this hearing, as I'm being told I need to talk to these kids. Where are they, by the way? Are they in school right now?
Yes, Judge, they are.
So, what time is their school over?
Lorelai gets out at 4:30, Jameson at 3:45.
What time do they start in the morning?
Jameson at 8:20, and then Lorelai at like 8:45.
So when were you expecting me to talk to him, Ms. Chapa? What's the plan there?
Judge, we wanted to go ahead and get some advice on when you had the availability to talk to them. If we would like, it would likely be easier to do Lorelai in the morning and then Jameson in the afternoon, since they're kind of.
And you want to do them by Zoom?
If the court is okay with doing them by Zoom, I know some judges prefer that we bring them in person, and I let Mr. Boyle know that. Realistically, we don't mind. I think Mr. Boyle would prefer in person so that there's no outside, so that we know there's no outside influence and they can freely speak to you. But logistically, since they're in Hutto this week, I believe, it wouldn't be feasible, I don't think, without them missing school. And
Right. Well, they're going to miss school. If I got to talk to them, they're going to miss school.
Okay.
So, Ms. Estes, yes.
I've been in contact with the counselors at their schools so that they can keep an eye on behavioral changes or whatever and let them know what's going on. They can be pulled from a classroom and do a Zoom meeting in a counselor's office so that there won't be any outside influences if you would like to do that.
Yeah, we might set that up for tomorrow. I mean, the problem is I have dockets, right? That's the other problem is I have dockets all this week. This week's kind of a tough week. Next week's actually probably easier for me because I'm duty judge next week and I don't have dockets. I have 8 hours worth of work tomorrow and 8 hours worth of work on Friday. So I'm looking at probably next Monday to do these conferences. And that's a long time to go without parents talking to kids about this case. And I'd rather parents not talk to kids about this case. But I'd rather work on maybe a setup for both kids next Monday where they just meet me by Zoom. I think that's probably best. Maybe they do it from the counselor's office. If that works. And I don't want to do it. I want to do it between the hours of 9 and 5. I don't want to do it at 8:30. Yes, Ms. Estes.
Could we arrange it during their lunch hours? They both have about a half-hour lunch break.
Well, yeah, but then they don't eat. So I don't really want to keep them from eating. So I think just talk to them about their schedules. I think they probably know enough to know this hearing is going on in some capacity. So it's not going to be too much of a shock that they get a chance to talk to the judge directly. And beyond that, I don't really want them to be told anything by either parent. And you can set something up with Frenchie. Frenchie, are you here?
I have their schedules in front of me.
You don't need to do this. I don't need to do their schedules. I need you both to figure out and tell and have Miss Chapa and Miss Simone get on an email with Miss Jones, my JEA, and tell her when they're going to be available. Both of them have 30 minutes in their schedules to talk with me separately next Monday. Frenchie, does that look okay on my calendar?
It does, Your Honor.
And so you're going to figure it out, talk to your lawyers. Your lawyers are going to communicate with Frenchie and tell her when each kid has a 30-minute block. It probably won't take a full 30 minutes, but I think that's a good plan. Like, I don't want to do it during the math test. I don't want to do it during the, important, fun pep rally. I'd like to do it kind of when they're just sitting in class and just having a regular lecture day, but I'd like to do it next Monday.
Your Honor, can I just, this may not even matter, but if the court needs to communicate with me on Monday, or I'm actually going to be in trial with Judge Crump Monday and Tuesday on a CPS trial. So I
don't need to communicate with any of y'all. I just need to set it up with the counselor at both places. Both parents need to talk to both lawyers. I need to get it set up with both counselors to give a Zoom hookup to meet with this judge next Monday. And we can send her the Zoom hookup. But y'all need to set it up. It sounds like it's more Miss Chapa's problem than your problem, Miss Simone, as she's the one who wants it. So, but it also sounds like Ms. Estes is the one who may have reached out to the schools already. So I just need y'all to communicate to each other about when that's going to happen. Next Monday between 9 and 5. 30 minutes for each kid separately by Zoom. Okay. So do you have any other witnesses, Ms. Chapa, other than Mr. Boyle?
No, Judge, I do not.
All right, then we move on to you, Miss Simone, and you may call your witness.
Thank you, Judge. I call Tatum Estes.
Miss Estes, please raise your right hand. In the testimony you're about to give, do you solemnly swear or affirm that you will tell the truth, the whole truth, and nothing but the truth?
I do.
You may proceed, Miss Simone.
Miss Estes, you heard the testimony from your oldest daughter before. Could you just tell the court your understanding of the breakdown of your relationship with her?
It's been 4.5 years since she's spoken to me, and I have asked anybody and everybody who was in contact with her if they had any information about it. I've emailed and texted and called her numerous times asking her, what did I do wrong? Please let me know. Let me fix it. I honestly don't know. She and I were best friends until 2 months before she moved out. She used to sleep in my bed every night up until January of 2020. And then she started not responding to text messages, coming home from work late. And just, I'm sorry.
There was some feedback somewhere.
Over the next couple months, she started, and the week before her 18th birthday, which was my week, in the middle of the week, I told her, I said, you seem really stressed out. You seem very short-tempered with me. Would you like to go to your dad's early this week? I just think you need a break. And she said, yeah. And then she has not spoken to me since. Her testimony brought me to tears to hear the things that she was saying. And I immediately texted her and told her that I loved her. And I am sorry if I ever made her feel like she was anything other than perfect. I've always said that she is an angel on earth. I think she's the most amazing person. I have never called her crater, face, or cunt. I did call her a brat, but I call all my kids brats. I call myself a brat. A brat is just somebody who's playfully combative, somebody who has intelligence and questions things. It was never meant to be insulting. And she was in therapy from 8 on. And my biggest thing to all of my kids is if you don't tell somebody that they've done something wrong, they can't fix it. And I've always told my kids, you have to come to me and talk to me. I am human. I am not perfect. I make mistakes. But if I'm doing something that you don't like, you have to come talk to me. And Shiloh never really picked up on. She has always been very non-confrontational and has had a hard time standing up for herself and expressing those things. And we would go to therapy, and I would tell her, I would give my kids free days. Hey, today's a free day. You can say anything you want to mom. You tell me anything. You write down lists, everything, and you let me know, how can I be a better mom to you? And Jameson and Lorelai would come back with things like, oh, I want to eat pizza more often because they were young.
I'll stop you there. I think we've probably got enough for the court there on that one. So let's kind of change topics with that.
I'm sorry. Can I talk about the food story? The day that she brought Lorelai food? Your Honor, do you mind if I tell that story?
I think you gotta wait for a question from your lawyer.
Okay.
Could you tell the court why she brought food for the kids?
Yes. It was during the 2022 ice storm, and everything was closed. Almost everything was closed. And I had made the kids lunch. It was Friday. I'd made the kids lunch. They both eaten, and then I had not eaten. And so around 2 o'clock, I told Lorelai had been acting out pretty badly that week, to the point where I had called my dad. I work for Austin Energy. I was working overnights during the outages. I had called my dad and asked him to come stay with the kids during the day so that I could sleep. So she was having some attitude issues that week. And so Friday afternoon around 2 o'clock, I said, oh my gosh, I haven't eaten and I'm getting ready to log into work. I'm going to run to McDonald's and get myself lunch. Jameson, would you like a milkshake? And he said yes. So I brought him back a milkshake, and I didn't go to Lorelai's room and offer her a treat because she'd been being a butt all week. So Lorelai immediately contacted Shiloh and said that I wasn't feeding her. And that's not what happened.
Okay. So let's talk about the move to Hutto, because that's the big contention of this case. How did you actually first tell Mr. Boyle that you were planning on moving?
In person.
And what was his reaction?
He said, we'll see about that, and slammed the door in my face.
Okay. And that's why you emailed him?
I had written up the email already and had it prepared because it's good to have things in writing and details, and I did not expect the conversation to go well. So I had already had that ready. And
you didn't send it until after his...
Correct. Okay. He slammed the door, and then I went to the car and hit send on the email.
Okay. And so what prompted you to want to move out of Travis County?
I've been working remote since COVID hit, and the city Austin manager in April of 2023 told everybody that they were going to have to start coming to the office 3 days a week. And when the kids were in IDEA or even Covington, I work 7 to 4. The schools don't open. Their front doors don't even open at 7:15. I couldn't drop my kids off at a gas station at 6:15 in the morning in the middle of Southeast Austin, East Slaughter, and leave them there. That wasn't a safe option. And Joe had recently, just a few months before, told me that they were moving to Corpus that summer. So I didn't think that he was available to work out a new way of getting them to and from school safely. So I had to find a place where they could get to and from school without me driving them, that I could afford. And I couldn't afford any safe areas in Austin. And the addresses that were attached to my house, the schools that were attached to my address were dangerous, and I didn't want them going there.
Okay. And when did you tell the children about the move?
As soon as we got in the car, immediately after telling Joe.
And so that's what time frame? November
5th. It was the Sunday when I picked them up.
And what were their initial reactions?
Jameson had a complete and utter meltdown. He does not do well with change. Lorelai started crying, sent a couple text messages, and then by the time we left Joe's neighborhood, she started asking me questions. I had taken her to Hutto over the summer because I knew that this was coming and I wanted her opinion. And so, and she loved Hutto. We spent a day up here. And so she immediately hopped on Google Maps and started doing the street view and going through and seeing, okay, where are we going to live? Where's that close to the school? Oh, they have a nail place right down the street. They have a Chipotle. They have a, so she started, I mean, it was just the initial shock.
So she was excited after the initial shock.
She was, yeah. Yeah.
And did you have any family therapy sessions to discuss the move?
I did. It was about a month and a half later, right, like the weekend before we actually moved in mid-December.
Okay. And was there anything in particular that you learned in the therapy session about these sort of big life decisions involving the children?
The kids were at some point after I told them, and after the fun week of excited that they, I mean, not Jameson, but Lorelai excited they were going to move, came back and Lorelai started texting me that, you know, she's 12 now. She has the right to decide where he lives. And I didn't have the right to make these decisions for her. And I immediately recognized this is going to need the therapist. I don't want to have this conversation on my own. And so when we got in there, you know, the therapist said that, you know, Lorelai felt she's a young adult. She's incredibly intelligent. She felt left out. She felt like I hadn't considered her opinion or her emotions on the move. And I told her, you know, we went to Hutto in the summer. That's why we did that. I knew this was coming. I didn't tell you until everything was in place because there were so many moving parts. And I didn't want to bring it up and cause any sort of strife or get excited and then lose it if something fell through. But I told you as soon as I possibly could. And so the therapist talked about she has anxiety about the unknown. And so we talked about how to have those conversations about things that are coming up without being inappropriate, because the therapist explained to the kids that there are certain things that I should not talk to them about. And Lorelai was really upset that I was keeping things to myself and not telling her everything. And so when she, you know, had heard it from the therapist, hey, mom's actually trying to do the right thing here, then she calmed down and we had a really good session. And yeah.
Okay. And they were at Idea Charter School for the fall of last year.
For only the fall semester.
Only the fall semester, okay. And you heard a little bit of testimony from Mr. Boyle about some issues that he didn't think were any of concern. Can you just explain what kind of issues, first of all, that Lorelai was having?
I received a text message from his wife that Lorelai was at school and blowing up her dad.
I'm gonna object to hearsay, Judge.
Sustained.
I haven't, sorry.
Hang on, let me ask that again. What were the problems that Lorelai was having without saying about any text messages?
Lorelai was getting threatened on social media. But that's here. I don't know how to say that's without being hearsay, because she's telling me what other people are saying. So, Joe's wife asked me to contact the school because Lorelai was afraid.
Okay.
So that, yeah.
Okay.
Because Joe couldn't.
Okay. And why couldn't Mr. Boyle take care of that?
He was busy at work, is what she said.
Okay. And what were the issues that you were having with Jameson?
Like I said, Jameson doesn't do well with change. In the weeks leading up to starting Idea, he had a full-on meltdown in the middle of JCPenney when we were trying to buy belts. He doesn't like belts. He didn't want to wear a uniform. So once we got in there, it was just all of the behavioral issues that we worked on the previous years had just completely unraveled. I was getting calls from teachers at least once a week talking about his behavioral issues. The crossing guard called one day and said he was running in traffic, which Lorelai said that's not actually what happened. And then Jameson got into his first and only fist fight at school. He punched another child.
So there was a lot going on for both children.
Yeah.
Okay. And so Jameson has been diagnosed with ADHD. Is that correct?
And dyslexia. Yes.
Okay. And when was he diagnosed with both of those things?
ADHD was, I want to say first grade, maybe second. And then dyslexia, because of COVID, took a little bit longer because that went through the school. We started that process in third grade, and I think it was diagnosed either spring of third grade or early fourth grade.
So this was after you were divorced?
Yes.
Okay.
Years, yeah.
And what was Mr. Boyle's response when you first discussed with him about Jameson having ADHD?
He said he didn't want his son documented on file as a retard.
Okay. And was Mr. Boyle in agreement with initially getting him tested?
No.
And how does his diagnosis affect his daily life?
He struggles with focus, obviously ADHD. He struggles with long-term or multi-part tasks are the big things. So, you know, I can say, go get this and he'll come back. If I tell him to clean his room, he completely shuts down. I have to pick up your dirty laundry, go pick up your trash, I have to break everything down. And it's the same thing with school. Homework, multi-step homework. Because of the dyslexia, he loves math. But once he started getting into word problems with math, he started fighting that. I will ask him in the mornings, did you take your medicine? Yes. No, he hadn't. So, you know, he just really struggles to remember what he has done and to keep tasks going. And he needs constant attention and reminders and lists and all of these things, both with homework and just daily life.
And how has he coped with the move to Hutto and the change of school?
By the time the first day of school, they were both very excited. You know, it was really just that first week that he the shock of the change. But once we got up here the morning of, and they were able to wear their own clothes and not uniforms, which, you know, it seems irrelevant, but it's so important to them at that age, their identity. They were super excited to be able to go. And I reached out on the Facebook.
I'll ask you another question first. And how are his grades at the school?
His grades are great. He's in all honors classes, all A's and B's. The spring was very difficult. A lot of reminding, but he's growing and taking the responsibility of that. And his grades are great. I'm so proud of him.
So would you say that he's settled now in the school that he's in?
Oh, absolutely.
Yeah. And he has the 504 accommodations. When did that first start?
After he was diagnosed with the ADHD. So that would have been first or second grade.
Okay. And there was a 504 meeting at school last fall. What idea wasn't there? Oh, what?
There was.
And did Mr. Boyle attend that meeting?
No.
And did he attend the meeting in January?
He did not.
Okay. So did he sign the 504 plan for the Hutto school?
I don't know. He was copied on all the emails. Everything was sent to him. I have no idea if he reviewed any of it or looked at it.
Yeah.
You know.
And with regards to Lorelei, has she been diagnosed with anything similar to Jameson?
General anxiety, but it's not anything that requires 504.
Okay. And when was she diagnosed with that?
She started therapy in early 2022. So I would say late spring, early summer.
And whose idea was it for her to have therapy?
Mine. And
what made you think she needed to have therapy?
Because she was having panic attacks every Sunday before going back to her dad's house. And she would call me multiple times a week crying, saying that she didn't feel like they loved her.
And object to hearsay, Judge.
Did you observe any kind of behaviors that sort of made you concerned about her?
About her, yes. I never felt that there was an issue with Joe or his house, which is why I wanted to put her into therapy, because I wanted her to advocate for herself and to have a strong relationship with her dad. So it was more about her learning to find her voice and to work through those anxious moments, so that she could have a strong relationship with him.
And is she having any struggles at the moment?
She's had some social issues this year. She lost a couple of her best friends at the beginning of the summer, but as of Monday, she just told me they've all reunited. So they're all friends again. So it's kind of a rough summer. Yeah.
And has there been any recent recommendations of therapy from the therapist?
Therapy just recently asked to bump her up instead of biweekly to weekly sessions again because of the social depression and or depression due to social issues.
And do you have any idea sort of what the social issues are?
No, the therapist is really good about keeping that safe space for Lorelei. So unless Lorelei invites us into one of those meetings, we don't hear that. It's just the things that Lorelei tells me. which of course is limited for a 14-year-old girl, but I know a big part of it was because of the loss of her friends, which she now has back.
And were these friends from Hutto, or they're from the previous schools?
They're actually from elementary. They've known each other for a long time. They have not been to school together in years, but they have stayed in touch. Both of them have come and had sleepovers up here in Hutto, and so they're very, very close.
So she still keeps in contact with old friends from when you were living in Travis County?
Oh, yeah.
Okay. And what about family members that are still living in Travis County? Does she keep in contact with them?
We see my dad every other week. When I drive them down to drop them off at Joe's, we see my dad every other week. And I have no idea I know that they see Joe's family on his time. But she's got lots of friends and family, and she talks to my sister and her nieces in North Carolina, and they've gone to visit her, and they come into town and visit. And so, yeah, she's got a big family, big support system. They both do.
So do you think that the move to Williamson County has affected any of the bonds that she's had with family and friends?
No, the only difference that has happened is that instead of my dad popping by 2 or 3 times a week for 5 or 10 minutes, which they usually wouldn't even come out and say hi to him. No, that's it.
Okay. And with regards to their schooling, how involved are you with the kids' school?
Extremely. I'm exhausted.
And what kind of things do you get involved in?
I'm a vice president of the 9th grade center PTA SA this year. I did band booster when Shiloh was in school. I go to all of the open houses, the excuse me, the course fairs, the college readiness presentations, the fish camps. I developed personal relationships with the faculty, especially with Jameson. And I know I have met and had conversations and reached out to most of their teachers, and I've done that every year they've been in school.
Okay. And so with regards to the possession schedule, Mr. Boyle testified that you've been doing a 50-50 possession schedules. Is that right?
Yes.
So the two of you agreed to deviate away from the decree because the decree was different. Is that correct?
Yes. Yes.
Okay. And have you attempted to have conversations with Mr. Boyle about the move and changing the possession schedule so it works for both of you?
Yes. And trying to keep our time as close to 50-50 as possible and make things easier on him. Yes.
Okay. And what has been the response?
No response.
Okay. And how do you feel about getting zero response from Mr. Boyle about any of these issues?
It makes me nervous because this may be whether or not we change our possession schedule may seem irrelevant, but what if he decides one day he's not going to respond to me about something urgent or a school issue, or you know what I mean? And we've always communicated. Even though we fought a few times, we've always communicated really well, and we've always talked about these things, and he's just completely shut down outside of, something very, very important. Our communication has just completely stopped since I informed him I was moving.
Okay. And do you think it's in the best interest of the children that their parents stop communicating like this?
Absolutely not.
And has there been any instances, because of this lack of communication, has there been anything that potentially the children have missed out on, or that you've had difficulty getting the kids involved in while this case has been pending?
Yes. I had reached out to Lone Star Soccer Club prior to while I was going to my move planning, and I informed Joe in the email that I've been trying to get a hold of somebody there and nobody would respond to me. The coach finally contacted me first week of December, and we had a brief conversation. And then I told him, I know we're moving up there, but if there's anything else, if we can either start Jameson on a team up here, I could take him to other practices. And he said he would let me know. He did not let me know until April, until after our last hearing. He told me that Joe was correct. He did reach out and offer one of his practices, but it was in Cedar Park during rush hour, which I would have just not been able to get there. And so he set me up with a team in Taylor to take Jameson to. And the first practice we went to, they had changed the time, so they weren't there. We went again the next time to the practice, and he was able to go to practice, and then the season was over. So I absolutely would have, Jameson, soccer's a part of his identity. And I absolutely would have gotten him, and he missed one game, not half of them. And I absolutely would have gotten him to practices had had somebody communicated.
So Mr. Boyle didn't communicate with you about the soccer. So okay.
No.
And so are you asking the court that Mr. Boyle start following a standard possession schedule?
I am.
Yeah. And why do you think it's in the children's best interest that he follow a standard possession schedule?
As the kids' school is getting tougher and more rigorous, and they need a more consistent environment, just for educational purposes, and they need more structure, and they need more support and help with homework and getting these things done. I have always been the person that has provided that for them. And if they go to him, I don't, if he can't even respond to 504 meetings or show up. So I worry that the support that Jameson needs is not going to be taken care of. And, Lorelai needs a lot of emotional support. And I don't know, I can't speak to that. And I had offered in the email, you take them every weekend, I'll take them during the week so I can handle the school stuff. And then you can have them every weekend, time's still about 50-50. This has never been about taking them away from dad. This has been about giving them structure and the best educational opportunity. And they need to really buckle down. We're getting ready to start looking at colleges, and transcripts matter, and they need.
Okay.
They need
and so
that.
you're not asking for the change in possession schedule purely because of the distance between the two of you?
Oh, no. We always commuted them to school. The idea for one semester, they were between our houses, but they've always commuted across. They're used to commuting 30 to 40 minutes a day to school because we always wanted them in better schools. The change is because of his reaction to this situation. And it worries me that this is not about the kids. This is not about their best interest. They're it's been 10 months and they're doing wonderful and they have friends and a life, and he wants to pull them out and he's not communicating with me. And if something's happening at school and I need to wait for him to respond in order to make a decision, that's going to hurt the kids. And he just has not shown me that he is putting them first. And that's what scares me.
Okay. And you're also asking the court that he begin paying child support?
Yes.
Okay. And at the time of the divorce, what was approximately your income?
It was around 60 or 70,000.
And what is your income now?
With my overtime, around 75,000.
Yeah. And so your income has stayed relatively the same since the divorce?
Yes.
Okay. And your understanding is that Mr. Boyle's income has significantly increased since the divorce?
Correct.
And how has the cost of living changed for you since the divorce?
Well, the general cost of living for everybody's gone up. We all know about that. But, as the kids get older, their clothes are more expensive. Their shoes are more expensive. They eat a lot more. Their social activities are more. They've got dances. They've got, Jameson, the sports, athletics, all these things that we suddenly have to do. Lorelai wants makeup and hair products. Just their everyday, day-to-day is just drastically increased as they get older. And it's only going to continue to get more and more.
And you're also asking for attorney's fees, is that right?
I am.
And how has this lawsuit affected you financially?
I'm about $15,000 in debt this year in legal fees, because he wouldn't have a conversation with me.
Yeah.
I truly believe that we would have worked it out had we gone and met with a therapist.
And have you ever offered to settle this case outside of court, non-suit, not change anything? Have you ever made any type of proposals regarding that?
Yes.
And what has the reaction been?
No response.
Okay. And do you have any concerns regarding the children if the court awards Mr. Boyle the exclusive right to designate their residence?
I do.
Can you just briefly explain what some of your concerns are?
He's never really cared about what school they're going to. I've always been the one that pushed for them to go to the better schools across town. I'm the one that's always done the transfer requests. When they were denied, I had to go get letters from therapists to explain why Jameson needs that consistency or what's going on. Done the appeals. I've always done that so they can have a better environment. And, every other year or so, he's asked if we can just put them at the school by his address, because I guess he wants to take them to take the bus instead of having to commute. And I just don't think that he would, if he were to be awarded, I don't think that he would keep them in those better schools. Lorelai was waitlisted at Bowie, but she was, I think, 37 or 57 or something like that. And Jameson was approved to start Bailey, but because he didn't start and then the paperwork was turned on, that transfer has been since rescinded. So if he can even get them in mid-year, and even if he wants to, is he going to start them at Paredes and Aikens and then try to transfer each year and then suddenly they have to move again. So it's just, I don't see the logic, and I worry that it's just going to be about his convenience and not their well-being and their best interest.
Yeah. And just finally, just with the braces issue, were you consulted by Mr. Boyle about the braces for the kids?
No, I think he texted me a week or two before and told me that Jameson had an appointment, but Jameson had already told me that this was going on. I was not part of any of the planning or decision or discussing finances. And with Lorelai had metal in her mouth for 6 years, that poor child. The orthodontist was actually set up to charge both of us 50-50 on those expenses. So anytime she had an appointment, they would automatically charge us both 50-50. And then when all the stuff came out and they were discussing a retainer versus a bridge, I specifically told him this is going to cost about $4,000, but the orthodontist has cheaper options. I can't afford that right now. Let's go talk to him together. And next thing I knew, Lorelai had the $4,000 item in. So he never responded to that. I was not included in that discussion. He has never sent me an invoice asking me to reimburse him for 50% of expenses. I pay for all my copays, and on my time, I've never sent him one either. You know, we just pay for those expenses on our time, but I was not included in any of those discussions or decisions.
Okay. That's all I have, Your Honor. Pass the witness.
All right, Ms. Chapa.
Thank you, Judge. Miss Estes, I'm going to share my screen really quickly with the court. You prepared a proposed support decision, correct?
Yes.
Okay. How much is is the 1950, is that your rent at your apartment?
Yes.
Okay. And I noticed on your documentation, it also says that you receive $450 from rental income. Where's the rental income from?
I still own my house in South Austin, and I rent it out.
Okay. What's the mortgage on that house?
$1,350, I believe, and I rent it out for $1,800.
Okay. So your house is in South Austin, you said, correct? You own a home there?
Yes.
So, and the rent or the mortgage there is cheaper than the rent you're paying right now, correct?
Yes.
You said you're 1950 and the mortgage is 13.
Yeah.
So isn't it true that you had a permanent residence and you opted to go to a more expensive place in Hutto versus keeping your children in South Austin where they had been for at least 6 years?
Yep. Correct. I was willing to pay $150 more to put my kids into better and safer schools. Yes, that's true.
Well, so would it surprise you to know? Well, so would you have wanted Lorelai to go to Bowie High School as well, to transfer into a better high school if you stayed south?
If she could have gotten into Bowie, yes. Joe and I both went to Bowie. It's a wonderful school, but like the judge mentioned, it's normally closed for transfers. I was surprised to see it was even open this year. Bailey's normally closed as well. So I never, every time I've looked, those weren't options. So I knew it was very low possibility.
Are you aware that, do you know what Hutto's rating is Hutto High School, what their rating is in comparison to a school like Bowie or Anderson or Austin High or any of those schools in the Austin area that accept transfers? Are you aware of what their rating is?
Yes, ma'am. I've researched all of that before I made my decision.
So you're aware that it's lower than most of the good schools in Austin that take inter district transfers?
It is fairly equivalent, and I have sent those side by side. It is slightly lower on some things, but it's fairly equivalent. And the issue was safety for my children. So I got them into a fairly equivalent school and was able to keep them safe.
When you say you were able to keep them safe, what do you say from what, Miss Estes?
Did you want me to? I can't drop them off at a gas station at 6:30 in the morning before I go to work.
Oh, okay. I'm sorry.
Yeah. It was about safety. The move was about getting my kids to and from school safely. And because Joe told me they were moving to Corpus, I didn't think that I could make arrangements with him. He was not an option in that decision. That's all it was.
When did Mr. Boyle tell you he was moving to Corpus?
In November of 2022.
And as of November of 2023, when you moved, had he moved to Corpus?
He had not.
Did he indicate that he was still planning to move to Corpus at that time?
He did not tell me he had changed his plans either. So until he had told me to change his plans, how was I to assume that might change?
Ms. Estes, is that a yes or a no? I'm sorry, just for the record.
Yeah. Can you repeat the question?
As of November 2023, had Mr. Boyle left for Corpus Christi, Texas?
Oh, no, he had not left yet.
Okay. And to date, has he left to Corpus Christi, Texas?
No, ma'am.
Okay. So you had a permanent residence in South Austin, somewhere with cheaper rent or somewhere with the cheaper mortgage, and you still decided to go ahead and uproot the children. Let me ask you something else. As far as the possession and access schedule goes right now, would you be willing to do a 50-50 opposite ways? Like, let's say that the judge did say, let's say the judge did say that they could go to school in South Austin at Bowie and Bailey. In a perfect world, we got them in. Yes. Would you be willing and able to make that commute to take them to and from school?
I would make it work. Yeah.
Okay. And as far as, let's talk about the dentist. Has Mr. Boyle brought an enforcement to your knowledge? Has he brought an enforcement against you to try and get fees for, the dentist and whatnot that he didn't, ask you about?
No.
And he hasn't asked you for reimbursement for it, correct?
No.
And were the braces, were those things in your perspective, and what you were told by the kids' professionals, were they likely going to be something that needed to be done?
All of Lorelai's stuff needed to be done. Jameson,
Okay.
the last time I spoke with the dentist, they made it seem like this is the recommended option, not a required option.
Okay, so Lorelai's dental work and everything like that was for her health. It was likely going to be a requirement.
It wasn't a health issue. It was just, she's going to have a lot of difficulty in crooked teeth, and we need to go through all these steps over the next several years. And now that we're at this particular step, here are 3 different options. And I asked Joe to come meet with me and the orthodontist at the same time so we could all talk about them together. He never did that, and he opted for the most expensive option.
But he covered it, correct?
I'm not the one who brought this up. Yeah. He covered it.
Just wanted to make sure. You mentioned that earlier in your testimony, you mentioned that the kids have their friends and they have a life now in Hutto, correct?
Mm-hmm.
And that's really important, right?
It is.
And you also mentioned that soccer is a part of Jameson's identity, right?
Mm-hmm. Absolutely.
Wouldn't you also agree that the dynamic that an athlete has with their coaches and their teammates is also a part of that identity when you're a player, right?
Yes. I've been on teams. Yes, I absolutely agree.
But you thought that it would be okay to take Jameson away from the team that he had built chemistry with and the coaches that he had built chemistry with in South Austin, right? Like, that was your suggestion.
I thought it would
correct?
be, I thought he played with them for 1.5 years. They changed their teams every year based on skill. There's a possibility that he was going to go to a different team at any point in time. I thought it would be
to non-responsive, Judge.
Except that's how club soccer works, actually, Ms. Chapa. You're not guaranteed the same team. I can't remember what Mr. Boyle testified about, but it does get restructured every year. They can move you wherever they want to. So I feel like that's probably correct. Now, I don't know if I can't remember what Mr. Boyle said. If he said this coach said he was definitely going to be on this team, I guess we could figure that out, but it's almost like the ship has sailed. But it does sound like both parents want him in soccer. So we need to figure out how to get him in soccer. But maybe we should go forward, not backwards. Though Lone Star is not exactly known for its flexibility with parents.
Yeah.
So I think that's fair, that it's difficult. You are sort of at their mercy, not the other way around.
So just for the record, Judge, preserve the record, the ruling from you for my objection.
I guess it's fine. I'm just telling you, like, what she was saying is accurate. I can't tell if he missed 6 games or 1 game. Both of them have a different memory of the world. And they have but I don't know. Are you saying that your client testified that he was definitely going to be on the same team?
Well, he did testify to that, but I was just asking her.
Okay, well, we'll come back to that. I'm curious about that. But so sure, if you want her to answer the question, I'm just telling you, this is the club soccer. Every spring is a whole new team.
Correct. Yes. Well,
yeah, that's just how it works.
But again, Right. It was a
Um,
yes or no question, so that's why I
Sure.
objected to.
Got it.
but
I'm just letting
I-
you know, like, there, I can't look away from what I know to be true about club soccer, where as a parent, I have spent 12 years in. So I
Understood.
recognize club soccer and all of its benefits and limitations.
Yes, understood,
Mm.
Judge. I'll move on from that line of questioning. So have you, to date, you still haven't enrolled Jameson in any forms of soccer?
He is in pre-athletics at school. He did not want to play football, but he is set to try out for soccer in the spring with the school.
Okay. And has he expressed any interest in playing with his former teammates?
He just wants to play soccer. Yeah. He has
Okay.
friends in school up here that are on different leagues. He just wants to play soccer.
Okay. And if the school issue, if the kids are basically, well, so the real issue here originally you said was schooling, correct? Like what school the kids are going to go to and who designates primary, right?
My issue was they needed to be able to get to and from school safely. That was my
Okay.
issue. That's why
That's how do they get to and from school? Because you have to go early to work. Do they walk?
So all of this ended up being for nothing because the city manager said we all had to go back to work 3 days a week. And then in January of 2024, after I'd already moved, apparently the union came in and fought it. And that was actually the case. But my particular department, the utility call center, was exempt from that rule because half of our agents don't live in Austin. They live around the state. So I still work from home full time. I only have to go to the office once a quarter now.
Do you think there's a world in which you would move back to your house that you currently lease out in South Austin?
There's a possibility. I mean, I didn't want to jump on selling it because you never know what's going to happen. I've been fortunate enough to have a good tenant so far that it seems to be working out, and I want to buy, but we all like it here. So probably not. I mean, I don't see any reason to move back south now.
Well, that sort of added even more complexity. I feel like we made a lot of decisions here, and I don't, and it almost feels like communicating parents would have worked these issues out, and instead we're all in a multi-month attorney's fees, basically mediation. I don't even know. I almost feels like no one's a bad parent here. It's unfortunate to me that y'all are here on a lot of different levels because y'all could work out something better than I probably come up with. There's a lot of ways to be creative with schools. There's a lot of ways to be creative with soccer. But it doesn't feel like we have been communicating. But that's just my observation. It's unfortunate that you all are here, I think. Go ahead, Ms. Chapa.
Thank you, Judge. Earlier in your testimony, you had also testified that you don't believe that Mr. Boyle is going to be involved and help the kids with their homework and do what needs to be done. Do you remember testifying to that?
Yes.
How are the kids doing in school right now?
Great.
What's the possession schedule right now?
50-50.
And so he has them 50% of the time, correct?
I know you're asking for yes. With context, yes.
Okay. So would you say that right now you're just kind of speculating that this is what's going to happen, but so far that hasn't been the pattern under your 50-50?
I would not say that, no.
No. And so how are they doing so well in school if Mr. Boyle is just not helping with homework and classes and anything during his weeks?
I spend a lot of time doing makeup work on my weeks, and I have plenty of documentation to show that. So
did you bring any of it with you as exhibits today?
I submitted it to my lawyer. I don't know if she's supplied them or not.
Okay. And as far as let's talk about the elementary school. You had mentioned that you were pretty much the one who primarily handled the schooling. Isn't it true that Joe's parent or Mr. Boyle's parents, y'all used their address so your kids could go to the better elementary school?
We lived with his parents. And then when we divorced, he lived with his parents. So he used his address while he lived with his parents.
Okay. And they went to school based off of his parents' address because it was the better school?
Because of where he lived. Yes.
Okay.
Yeah.
And then did he look into getting them admitted into Idea School?
He did ask that because I said no to every other school in the area. So when IDEA finally opened, he asked, can we move them into this school? And that I finally was willing to put them into a closer school because I felt like it would be a good enough program.
Okay. And you heard testimony earlier about him looking into other schooling programs that he thinks are good. Do you have any issues with the schools that he suggested if they were able to get into those schools?
Bailey and Bowie, no, not at all.
Okay. And does he take the kids to, or does he have Lorelai go to therapy during his possession times as well?
For the last year or so, they've both only gone on my weeks, but we do it virtually.
Okay.
Which is what they've done the majority of the time. If they have therapy on his week, he will take them.
Oh. But you also said that the therapist is recommending weekly now with Lorelai, correct?
Right. So,
okay.
Whether or not he chooses to drive her or not, that's his decision, but virtual, they do most of their appointments virtually.
Okay. And have you shared this information with, or was today the first time that you shared this information with him?
What information?
Over increasing Lorelai's therapy sessions.
The therapist emailed both of us last week and we both responded that we were okay with it.
Perfect. So y'all are both in agreement. So there's really no concerns over her, how either side is handling her mental health issues related to therapy?
No.
Okay. No further questions for the witness, Judge?
All right, Ms. Simone, finish up.
I have no further questions for my client.
Okay. And do you have any other witnesses?
No, just myself for attorney's fees.
Why don't you both send me an affidavit about your, actually, we can hold off on attorney's fees because I need to talk to the kids next week. We'll just leave the record open and I'll reschedule y'all to finish up with attorney's fees when we're done. I'm going to talk to the kids and see what they have to say and what their preferences are, because I think at this age, they get a chance to weigh in. Not always the best interest, what they say they want. And so we can do attorney's fees when we reset you for a motion to enter, or you can do it by affidavit. That's fine with me too.
Do you have a preference, Judge? Do you like affidavits or would you prefer oral testimony?
I don't really have a preference. If Ms. Simone wants to do it live when we do the motion to enter and kind of follow up, it'll be like closing the record and motion to enter, right? I'll rule after I meet with them. We'll circle back and I'll find 30 minutes on my calendar for y'all to either testify about attorney's fees or just do them by an affidavit.
Okay.
All right. We'll see what they say and I'll talk to them. I also have to be realistic though. I'm telling you this on the record about what's possible for them, because so much of this seems about schools and I don't know. I don't want to tell them things that can't happen, but I'll be curious what they will say about their current school situation and what their future school situation is. And we will schedule a time for me to come back and rule and take up the attorney's fees issue. Thank you. Everybody is excused for now. We're going to go off YouTube.
Thank you.
Y'all will reach out to Frenchie and set up that meeting.